Okay, good morning and welcome to the August 18th, 2021 meeting of the Colorado Oil and Gas Conservation Commission. We are going to go ahead and get started. It's 9:32 a.m. per my clock, and we will start with a call of the roll.
Thank you, Mr. Chair. Commissioner Bove, Commissioner Gonzalez,
Here.
Commissioner Hackett, Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Nanjapa,
Here.
Commissioner Robbins. Mr. Chair, you have 4 out of 7 commissioners present.
Thank you, Ms. Larson. The next item on our agenda is the consent agenda. Do we have any questions or discussion from the matters on the consent agenda? Seeing none, do we have a motion on the consent agenda?
I move to approve.
Second.
We have a motion and a second. Any discussion? Seeing none, all those in favor? Aye.
Aye.
Okay, that motion carries, and we will move on to the continuation of docket number 2011-00261, enforcement matter of COGCC versus KP Kaufman Company, Inc. And this is the second part of our of the ongoing matters in this docket, and we will be taking up openings and presentation of case on the matters: the Grant Tank Battery NOAV, the Charter Schneider Tank Battery NOAV, and the Wagner No. 1 NOAV in that order. So if we're all ready to get started, I think we are ready for staff opening. Is there anything before that, Kyle?
Yes, Chair. I have a couple of things. Commissioners, the Commission did not close the record on the 5 NOAVs for which the Commission deliberated on Monday, excuse me. I'll turn my video on. So I suggest a couple of things. First of all, that the Commission move to close the record on that, and I can read that motion out and with the appropriate NOAV numbers so that it's clear for the record, and then you can just simply say so moved if that's your pleasure. And then the other thing is I just want to remind commissioners, I would like to check in with the parties at some point, maybe after closing or before closing, whenever is your pleasure, and make sure that we don't need to swear in more witnesses. And just to remind the witnesses as well that if they were previously sworn in, they should consider themselves to still be under oath for these 3 NOAVs as well. So first matter, if it's the Commission's pleasure, I can suggest a motion to close the record.
Please do.
Okay, thank you. Commissioners, I suggest a motion that closes the record on NOAVs 402-523412, 402-550681, 402-548397, 402-494406, and 402-571143.
So moved.
Second.
We have a motion and a second. Any discussion? All those in favor?
Aye.
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 That motion carries, and I believe that sufficiently closes the record on the first 5 NOAVs we have heard in this matter. Next, do any of the parties have any additional witnesses that need to be sworn in?
Thank you, Chair. Staff does not have any additional witnesses to be sworn in.
Mr. Chairman, respondent KP Kaufman Company does not have any additional witnesses to swear in. We do have one point of order we'd like to raise very briefly with your permission.
Go ahead, please.
We were wondering if there were any constraints on the scope of the public comment session scheduled for this evening. And if you could elaborate on that. This is public comment under Rule 512, I believe.
AAG Davenport has a comment on that.
Thank you.
Commissioners, my suggestion is that the Commission treat this evening's public comment session in a similar manner to the written email that you received from Mr. Ladkey last week, in that it's not appropriate at this stage in the midst of the hearing to take or consider public comment on anything you're considering in this entire hearing, including last week's presentation of NOAVs and deliberations. So my suggestion is that we do make a statement at the outset of that the commissioner will not be considering public comment specifically on these matters if it's made this evening.
So we'll go ahead and set that comment out ahead of the public comment when it commences at 6 p.m. tonight. And I think that should sufficiently keep any of that out of the record, and hopefully keeps our public comment to matters outside of the KPK matter.
If I may, Mr. Chairman, I do have a concern. I appreciate Mr. Davenport's advice to the commission and the notice that you'll provide regarding public comment this evening. But this public comment was set before we bifurcated and Chairman Robbins' recusal. It comes in the middle of your consideration as fact finders, the 3 NOAVs before you in this second phase of hearing about to start. And I think it frankly is objectionable because it has the potential to sway your judgment regarding specific alleged violations in these 3 NOAVs. If it's not constrained public comment, I do appreciate the notice that Mr. Davenport suggested, and then I take it you intend to make at the beginning of public comment. But these public commenters are not sworn. We don't know who they are. They're not subject to cross-examination. And those are concerns in an enforcement hearing, notwithstanding that Rule 512 was revised by this commission in the mission change rulemaking to allow for this public comment.
Thank you, Mr. Jagus, and I appreciate your argument in that regard. I think that we've been through enough public comment and enough of these that we understand what we're going to be hearing and the perspective of the public commenters. It is outside of the hearing matters themselves, and so we're going to go ahead and make that comment ahead of public comment tonight at 6 p.m. And then we'll hear what we hear from the I believe 6 public commenters that we have signed up tonight. So,
thank you, Mr. Chairman.
Ms. Stafford.
Sure, if I may.
Sure.
2 preliminary matters. One, I've actually just been corrected that one of our witnesses was not previously sworn in, and I apologize for the mistake there. This is Mr. Mark Schlagenhoff. He will be testifying during the Charter Schneider NOAV matter.
Is he available now to be sworn in?
I do not see him in the attendee list, but I will make sure that he is available very soon.
Ms. Larson has found him in the
Oh, okay.
Attendee list, so she's going to go ahead and elevate him to a panelist, and we'll bring him up, we'll get him sworn in, and that way he'll be ready to go when his testimony comes.
Thanks, and apologies again for misstating that.
Let me know when he's up. I am seeing Mr. Schlegenhoff as a panelist. So if he can go ahead and unmute, I think AAG Davenport has the swearing in language that we'll be moving forward with.
Thank you, Chair. Mr. Schlegenhoff, would you please turn your video on as well when you unmute? Thank you. Good morning. Sir, all I need you to do is raise your right hand, state your name, and say that you swear to tell the truth.
My name is Mark Schlagenhoff. I swear to tell the truth.
Okay, thank you. That's all we need. And Mr. Schlagenhoff, you should consider yourself under oath for the entirety of the hearing. We're not going to re-swear people in at the beginning of a new portion of testimony or whatever.
Okay, thank you.
Thank you.
And with that, just an additional reminder that, and AG Davenport made this a few moments ago, but to any additional to any witnesses that have been sworn in previously, that remains throughout the remainder of their testimony for these 3 NOAVs as well. So with that, I think we're ready to get started with presentation.
Chair, I have an additional preliminary matter I'd like to raise.
Ms. Stafford.
Thank you. And thank you, commissioners. So prior to getting started on the presentation of the upcoming NOAVs, and based on your interim decision on Monday with respect to the statute of limitations and the continuing violations doctrine, staff evaluated the upcoming NOAVs to comport with your interpretation. And as a result, we have made the decision that we are no longer going to pursue the Wagner NOAV, which was slated to be heard by you on Friday morning, according to the agenda. If you can indulge me just for a few minutes, I just wanted to point commissioners to the stipulated facts which are already in the record, and just orient you to the Wagner NOAV. This NOAV dealt with the Wagner location located in Logan County, Colorado. There were 3 alleged violations of prior rules 905B, which deals with having a work plan in place to close a skim pit. Prior rule, 906D, which deals with secondary containment, and then prior rule 907A, which deals with properly cleaning up and removing non-E&P wastes. And again, commissioners, I point you to the facts, the stipulated facts that are already in the record here. You know, the timeline of events here with relation to the skim pit, it was initially discovered during an October 3rd, 2017 inspection. A work plan was submitted on October 25th to close the skim pit on a particular schedule. And that schedule said that it would be closed on May 25th, 2018. If you're following along with me, I'm on page 16 of the stipulated facts. And then on February 11th, 2019, COGCC received a complaint from a landowner regarding lack of production and maintenance issues at this particular location. April 2nd, there was an inspection by staff where staff observed or noted issues related to the secondary containment and also the spillage of gearbox lubricant, which constitutes non-E&P waste. And that was staining the soil at that particular location. Again, in the stipulated facts, between April and November 2019, KPK was not able to access the location because of a dispute with the landowner. December 3rd, KPK submitted a field inspection report resolution form to respond to corrective actions. But as stated, and I'm on page 17 now, the KPK actually went to the wrong Wagner #1 location to perform this maintenance work. And then on December 12th, the staff re-inspected the location and determined that the corrective actions had not been completed. So I would point you to the stipulated facts there. That's what's contained in the record. If you'll recall, this particular NOAV was issued on July 16th, 2020. You know, based upon your determination, your interim decision on Monday with respect to the statute of limitations and the continuing violations doctrine, staff does not feel at this time that we can pursue this particular NOAV. And we would ask for some direction from you here if you would prefer that we file a motion to withdraw. We can do so. I don't know that, I don't think that Mr. Jacobs and his client will have an issue with us moving to withdraw at this point, but I obviously would appreciate if he had an opportunity to respond to what I've just discussed here. This decision was carefully made. It took a while to wade through the facts here and to determine that this was the appropriate course of action. So we do just want to let you know that, presenting it here this morning to you, it was not a decision that was taken lightly. So with your direction, we'd also like to come back this afternoon and potentially discuss timing as it relates to, I guess, the remaining NOAVs that are before you. And I'll turn it back over to you now.
Thank you, Ms. Stafford, and I appreciate the thoughtful engagement and reflection of what was deliberated on Monday and application to these set of NOAVs. That being said, I think that if you're prepared to make that motion orally, we could hear that now. And assuming there's no objection from respondents' counsel, I think we could hear that.
Mr. Chairman, with your permission.
Mr. Jacobs?
We do not object to a motion to withdraw the Wagner #1 NOAV. We appreciate staff's thoughtful deliberation on that point in light of your ruling on statute of limitations. To the extent there's a motion with some of the stipulated facts, perhaps, that Ms. Stafford has recited in part for you this morning, in that motion, we may wish to simply respond to make a record on that, but we certainly do not oppose a motion to withdraw and will not oppose that. That's our only concern with this news. Thank you.
I see Commissioner Messner has his hand up. Commissioner Messner?
Thank you, Mr. Chair. As I do believe this is going to be a full commission decision as far as making a ruling on this particular motion. And while I appreciate the oral presentation of facts in this motion and utilizing the stipulated facts that we have, I would prefer to see this motion in writing so that I can analyze it, compare it against the rules, and see if I concur. And so that's where I'm at. I would rather see this motion in writing.
Do any other commissioners have comments in that regard? Commissioner McGowan, I'm sorry, I see your hand up.
Okay, I think I agree with Commissioner Messner. That way we can look at the dates and the facts and kind of go do a side-by-side and make sure that we're all comfortable making that decision. And I do appreciate staff looking at that and taking into account the discussion we've had over the past couple of days. I appreciate that.
Does staff think they could have that written motion done by the end of today?
Tomorrow. They're in hearing all day today.
Well, I understand you're in hearing all day today, so perhaps maybe some time into tomorrow. Well, Stafford, what do you think is appropriate for this written motion? How about that?
We can definitely get it to you tomorrow morning at the latest. We will endeavor to get it to you this afternoon if possible.
Okay, let's go ahead and do that. So we will we'll table this until we have a written motion, and then the commissioners will read that, entertain it, and have discussion with the AG Davenport on what the next steps are. We may hear arguments on that motion, or perhaps that motion will be sufficient to just take a vote on, and we will move on from there. So with that being said, are we ready to commence with today's matters beyond that? Anything, should I ask anything additional from council?
Just a brief clarification, if we should email the motion to you or if we should file it in the system, just to make sure that we're doing this right.
Could you do both?
Sure.
Perfect.
Mr. Chairman, if I may.
Mr. Jacobs?
Thank you, Mr. Chair. My only point of clarification would be that our opening statement does address Wagner #1 statute of limitations. And given that you're requesting a written motion and perhaps an opportunity to respond verbally, it's fine. We don't want to slow things down. I'll include that. I'll keep that in our opening statement. I just wanted to clarify that for you.
That's fair enough, Mr. Jacobs. I think that's appropriate given that we haven't responded to that motion yet. So
very good. Thank you.
All right. With that, I think we are ready to get started. And so if staff is ready, we will hear opening statements on the remaining 3 NOAVs subject to docket number 2011000261. Ms. Stafford, you have the floor.
Thank you, Chair. Just bringing up my information here. I guess if I may, for a brief minute, along the lines of what Mr. Jacobs just mentioned, that his opening also mentions Wagner, I will, I guess at this point, keep references to Wagner in my opening as well, and then you can make your determination on the motion later if that is appropriate.
I think that's appropriate.
Okay. I need the ability to share my screen if possible.
We will get that set up for you, Ms. Stafford.
So as I'm sharing, can everybody see and hear me now? Great. Okay. Good morning, Commissioners. I'm Caitlin Stafford, Assistant Attorney General and Counsel for Commission Staff in docket number 2011000261 et al. With me again is Kelly Rosenberg, COGCC Enforcement Officer. As you know, this portion of the hearing is comprised of 3 notices of alleged violation, or NOAVs, alleging multiple violations at several different distinct Commission rules, which I will describe as we go forward here. And as I mentioned in the previous phase of this hearing, the Commission rules at issue here are rules that were in place prior to January 15th of this year. We are not discussing the Commission's current rules. In this phase of the hearing, you will again hear testimony and see evidence that will show, more likely than not, that KPK committed a variety of Commission rule violations. No work plan provided to notify COGCC staff of work being done to remove a partially buried vessel that was located some 33 feet from an unnamed stream. No notice provided of another spill uncovered as a result of that work. No best management practices, no signs, adequate fencing, no stormwater protections employed at a site subject to 3 separate remediation projects to remediate 3 separate spills. Open and unsecured flow lines at the same location with no obvious indication on when, if ever, they'd be used again. A skim pit approved for a specific remediation timeline that was not touched until more than a year until work was supposed to be completed. And work to address corrective actions regarding berms and stained soil that was not even completed at the right location. Previously, I told you that KPK is an unreliable, incapable, and impactful oil and gas operator here in the state of Colorado. And you'll see these descriptors hold true through the testimony you'll hear in this phase, and through the exhibits and stipulated facts that are already contained in the record. Each NOAV at issue here tells the now familiar story of deadlines that pass, corrective action due dates that are not met or otherwise complied with, and the actual or threatened impacts to the public and to the environment that follow. First, we'll discuss the Grant Tank Battery NOAV, where remediation has been ongoing since late 2018. On July 1st, 2019, staff arrived to perform an inspection and review the progress of KPK's cleanup and remediation efforts at this location. Approaching the tank battery, staff observed KPK personnel using equipment to lift a partially buried vessel from its location 33 feet or about 11 yards from the stream. Staff observed the area surrounding the vessel had been excavated. And upon further inspection, staff also observed both soil and potential groundwater impacts in the open excavation. From the information staff was able to gather on site, the work was not being completed as part of an approved remediation work plan. In this matter, staff has alleged violations of two separate commission rules. Prior Rule 905B, which requires operators to close partially buried vessels in accordance with an approved Form 27 remediation work plan, and prior Rule 906B, which requires reporting of any spill that impacts or threatens to impact sensitive receptors, such as waters of the state, occupied structures, or a public byway. We'll also discuss the Charter-Schneider Tank Battery, NOAV, which generally concerns three separate remediation projects resulting from three separate spills. At this location, staff will show you how KPK was incapable of keeping up with each remediation project, leaving the longest running project open and unresolved for almost 4 years. And as set forth in the stipulated facts, KPK couldn't even properly keep track of the three remediations. Staff will also show you that over the course of KPK's remediation efforts at the site, it was obvious that progress was slow and that work at the location would stop for long periods of time. And during those long periods of time, KPK was unable to adequately secure the location to keep out wildlife and the general public, unable to maintain stormwater protections to protect from the potential impacts of migrating spoil piles, unable to secure unused flow lines, and even unable to keep a sign up so that if there was an issue on location, emergency personnel or another third party would know who to call. In this matter, staff has alleged violations of 6 separate prior commission rules. Rule 210B for failing to keep a sign posted at the location. Rule 603F for failing to remove unused flow line equipment from the location. Rule 603F for failing to adequately fence the excavation to prevent public access. Rule 901C for failing to submit required additional environmental documentation. And Rule 1002F for failing to install stormwater BMPs to prevent erosion of spoil piles. And Rule 1105B for failing to lock out and tag out risers in the process of abandoning flow lines. Now the final NOAV concerns the Wagner number 1 location. And as I mentioned previously, before getting into my opening here, staff is concerned regarding the potential statute of limitations impacts here. But here, staff will show that KPK's proposed work plans were unreliable and that KPK is incapable of maintaining a location in line with its obligations to the COGCC. Following a fall 2017 inspection at Wagner, KPK submitted a remediation work plan that was ultimately approved with a planned remediation completion date of May 25th, 2018. Fast forward to February 2019, when staff received a complaint alleging a lack of production and maintenance at the Wagner location. And when staff performed an inspection, the skim pit was still in place. The berms intended to prevent a potential spill from the crude oil tanks were barely there, and gearbox lubricant had seeped into the soil at the pump jack. Staff required KPK to address each issue and provided a deadline by which to do so. Not only did KPK fail to meet the corrective action deadlines provided by staff, but it failed to perform the corrective work at the right location. In December 2019, KPK submitted a form purporting to show that it had finally complied with staff's request to maintain the site. However, KPK's supporting photographs showed that they completed the corrective work, not at the Wagner location at issue in this proceeding, but at another similarly named location in another county. It took another month for KPK to get to the right Wagner location to address these issues. And in this matter, staff has alleged violations of 3 separate commission rules. Rule 905B, Rule 906D, and Rule 907A. Again, you'll hear from staff witnesses with firsthand experiences at each location. You'll also hear from staff witnesses with more specialized experience that will talk about how a particular rule applies and why. And you'll have available to you staff exhibits, comprised mainly of inspection reports and documentary photographs that will further tie these violations together. And again, many of the facts and timelines we'll discuss are memorialized in the parties' joint stipulated facts. As in the previous phase, KPK may try to make these violations seem more complicated or confusing. As indicated in their pre-hearing statement, they might tell you about how historical contamination prevented them from updating staff and submitting proper documentation, or how they never intended to abandon flow lines, even though the flow lines remained uncapped and out of use for months, or how they actually weren't removing a partially buried vessel, even though a COGCC staff member observed them doing just that. It remains staff's burden to prove by a preponderance of the evidence, or more likely than not, that KPK should be found in violation of each rule as alleged in each of these NOAVs. And in the end, the testimony you will hear, the evidence in the record, including the exhibits and stipulated facts, will show that KPK is in violation of the rules as alleged, and that KPK is an unreliable, incapable, and impactful operator. Staff asks that you find KPK in violation of the Commission's rules as alleged, impose staff's requested penalties and corrective actions, and order any other necessary and appropriate relief. Thank you.
Thank you, Ms. Stafford. Mr. Jacobs, will you be giving the opening comments for KPK?
Yes, I will, Mr. Chairman.
You have the floor to proceed.
Thank you. Chairman Gonzalez, Commissioners, this second phase of the twice bifurcated order finding violation hearing in this docket concerns 3 notices of alleged violations served on the respondent, which are disputed in numerous significant respects, ranging from violations that are time barred by expiration of the statute of limitations at one location, the Wagner No. 1 well, to the lack of violations outright, to the mischaracterization of violations and excessive calculation of penalties sought by staff, well in excess of historic penalty assessments for comparable violations. We again urge you to follow the dictates of your own Rule 514 as you listen to the evidence and testimony during this hearing, being mindful that staff still bears the burden of proof in this second phase of the OFB hearing. Staff's mantra for this OFB hearing is apparently alive and well in this second phase. Of course, as I told you in my closing of phase 1, unreliable and incapable are terms that go well beyond the proper scope of argument and inquiry in this liability and rule by rule penalty calculation phase. These are not elements of the specific alleged violations, period. And regarding the third prong of staff's mantra, pay close attention to staff's evidence of actual and threatened impacts under the rules at issue. It seems most anything staff alleges in the way of violations elicits their reflexive recitation of this commission's charge to be protective of public health, safety, welfare, and the environment. And I certainly do not mean to denigrate that very important function of this commission's rules, but I know you can be discerning in your review of staff's allegations of actual and threatened impacts, as you must. Staff has the burden of proving such impacts by a preponderance, and you hold the scales of justice, determining whether a preponderance weighs in staff's favor or not. Regarding KPK's statute of limitations defense, we concur in your finding in phase 1 that for statute of limitations purposes, the continuing violation doctrine does not apply, and the 1-year limitations period in the Oil and Gas Conservation Act begins to run when staff discovers or should have discovered through reasonable diligence a violation of the commission's rules. Applying that finding to the facts of the Wagner No. 1 location, NOAV 402-373-684, note that the NOAV was served more than a year after the seminal violations occurred, as will be established through stipulations, staff's own exhibits, KPK witness testimony, and cross-examination. You must therefore dismiss this NOAV for Wagner No. 1 as barred by the statute of limitations. At one of the remaining 3 NOAV locations at issue in this second phase, you will hear testimony, expert opinion, and review exhibits regarding the existence of historic contamination for which staff has not established that KPK is the responsible party, and yet KPK has expended significant efforts and resources during very challenging times for the company due to commodity price volatility and COVID-19 related labor constraints, among other factors. The site with historic contamination that KPK has diligently addressed is the Grant Tank Battery location, NOAV 402-206828. Indeed, you will hear testimony and expert opinion that indicate a single historic release of significant volume and no corresponding release attributable to KPK operations, that indicate the areal extent of historic contamination is significant, has become weathered over a significant period of time, and did not come from a partially buried vessel that staff claims was being closed in violation of certain commission rules. And if you should find a violation at this location, justice and fair dealing require that any penalty be adjusted to account for the expense of addressing historic contamination not proven to be the result of KPK's operations. To do otherwise would convert the Oil and Gas Conservation Act into a strict liability statute. In addition to these significant defenses of statute of limitations and not being the responsible party for historic contamination at one location, KPK disputes alleged violations at a number of locations. For example, at Grant Tank Battery, staff alleges a violation for closing a produced water tank without prior notice to staff, but the testimony and facts will show that the tank was being reset after becoming dislodged, perhaps as a result of a storm event or events, and that evidence of contamination revealed when the tank became dislodged was not caused by that tank or any known release from KPK operations, and had been previously reported to staff as historic contamination months prior. Also, at the Charter Schneider location, NOAB 402-363-430, staff alleges a violation concerning requirements for the removal of risers, but no risers were involved at that location, only flow lines to repair and abandon lines encountered unexpectedly when excavating to remediate the release that was promptly reported for that location. Staff also alleges a lack of BMPs for stormwater runoff prevention at the Charter Schneider location, but the evidence will show the pre-existing tank berm and the excavation itself prevented any stormwater runoff from soil that was being staged for hauling off-site for proper disposal. Still, other violations, though minor in nature, are the subject of huge penalties by staff due to compound violations that can and should be consolidated under the staff's own penalty policy, such as a failure to report an incident in 72 hours and again in 10 days for the same alleged failure to report an incident that is not even subject to reporting requirements, the previously disclosed discovery of historic contamination at the Grant Tank Battery location. Such approaches to penalty calculation are excessive and certainly do not produce penalties which are comparable to penalties assessed to other operators for similar violations, which is a primary goal of the Commission's penalty policy. The huge penalties sought by staff in this consolidated proceeding are also driven by staff's belated and objectionable expansion of relief requested in this consolidated OFB hearing. That is because once staff seeks that extraordinary relief, staff is compelled by the penalty policy to calculate maximum penalties, and this has not been altered by the hearing officer's bifurcation of pattern of violation and knowing and willful allegations for a separate phase of hearing. And there are still more common alleged violations that simply suffer from a lack of preponderance of evidence demonstrating an actual violation. The adherence to stormwater BMPs for excavated soils and the use of temporary fencing to prevent entry to an excavation area are examples common to the Charter Schneider NOAV. The evidence and testimony will show that tank-related berms and the excavation itself were effective at containing potential runoff, and staff has no evidence to the contrary. Alleged lapses in maintaining berms and fencing reflects a failure by staff to acknowledge the changing dynamics of an active remediation site. There is no evidence of actual or even legitimate threatened impacts, and staff's allegations of inadequate BMPs or inadequate fencing are vague, subjective, not supported by photographs, and lack support in specific rule requirements. Moreover, testimony will show that KPK continued to repair berms and fencing that were modified to allow access for remediation crews, yet staff assumes that conditions observed on one visit represented uninterrupted conditions since the preceding inspection and has proposed fines accordingly. Moreover, perhaps because staff is compelled to seek maximum penalties by virtue of its expanded relief sought in this hearing, it fails to toll assertedly continuing violations, even for failure to submit forms, while KPK was waiting on staff to review and respond to requests for reclosure or to backfill and the like. Likewise, even when access was denied KPK to perform required work for months or to make corrective actions and satisfy conditions of approval, such as at the Wagner number 1 location, staff has failed to toll days of alleged violation in its calculation of proposed penalties. That is how staff was able to calculate such significant proposed penalties for these 3 NOAVs at issue in this phase of hearing. And that was done without regard to staff's allegations of a pattern of violation or knowing and willful violations, which will be heard in a subsequent phase of this hearing yet to be scheduled. It is your obligation to right size and equitably adjust these excessive proposed penalties, consistent with the penalty policy and all notions of consistency and fairness in the administration of the Oil and Gas Conservation Act. These are examples of the type of excesses engaged in by staff in their pursuit of enforcement against respondent KP Kaufman Company, a proud family-owned oil and gas producer and field services provider for over 37 years. You will hear evidence and testimony regarding still other hotly contested allegations and proposed penalties as well. Please pay close attention to the evidence and testimony, as is your duty in this type of hearing, especially when so much is at stake. Staff bears the burden, especially in these, and may not compound violations to maximize penalties, and must toll days of violation equitably, especially in these extremely challenging times. Because staff has failed to do so, you must step in to ensure fairness and consistency in the administration of the Act. Thank you for your attention. That concludes our opening statement.
Thank you, Mr. Jacobs. I think we are ready to move on with witnesses and testimony for the first NOAV at issue, which is the Grant Tank Battery, and that is NOAV 4022068828.
And Mr. Chair, Ms. Rosenberg will be presenting on behalf of staff.
Ms. Rosenberg, whenever you're ready.
Thank you. Just one moment to share the right screen. Sorry. Having just a bit of a technological issue here. I'll do my opening now, and then I will try again to get my presentation up for you all. Excuse me. Good morning. In this matter, KPK committed 2 2019 rule violations. Rule 905B for KPK's improper removal of a produced water vessel, and Rule 906A for KPK's multiple spiller release reporting failures. Almost all relevant facts have been stipulated to by the parties as described in the pleadings. There are 2 facts at issue for you to decide. First, you need to determine whether KPK was removing a partially buried water vessel on July 1st, 2019. This fact is relevant because if KPK were removing the produced water vessel, they would have needed to have filed a Form 27 prior to doing so. With regard to this fact, Chris Canfield, Staff Environmental Protection Specialist, will describe how on July 1st, 2019, he saw KPK attaching a produced water vessel by a chain to a backhoe to pull it out. He will describe how the excavation around the vessel was nearly 6 feet deep and surrounded the entire vessel. Mr. Canfield will explain how, when he spoke with KPK staff on that date, they expressed confusion, saying they didn't know they needed a Form 27 for this task. The evidence will also show that KPK ultimately removed the vessel in question. KPK will argue that they were merely conducting maintenance and not removing the vessel. They have claimed all along in their written documents that a heavy storm event the prior week dislodged the vessel. But the evidence shows that there was less than an inch of rain at the battery the week prior. And Mr. Canfield will describe how excavating entirely around a vessel and hooking it up to a backhoe with a chain are removals activities, not maintenance. And KPK's ultimate removal of the vessel also cuts against KPK's assertion. Second, you must decide whether the hydrocarbon impacted soil below the produced water vessel constituted a reportable spill or release. On July 1st, 2019, both KPK and Mr. Canfield observed hydrocarbon impacted soils in the excavation under the produced water vessel, which the parties stipulate was within 50 feet of a water of the state. Mr. Canfield told KPK to file a spill report, which triggers other reporting requirements to the local government and surface owner. But KPK replaced its judgment for that of the regulator and ignored that directive for over 3 months. Now KPK says the release was caused by the prior battery operator, which would make the spill over 24 and a half years old when staff first observed it in July 2019. And for that reason, KPK believes it should be relieved of its duty to report, even though the rule does not exempt an operator from reporting historical spills or releases. KPK further argues that it didn't need to report the spill because it had an existing remediation project at the Grant Tank Battery. Staff will clarify that even if KPK misunderstood the reporting requirements, lack of knowledge of the reporting requirements is not a defense, and staff will describe why it needs to rely on operators to report newly discovered spills or releases, regardless of their age, in order to properly protect the public health, safety, and welfare. At the end of the day, the evidence will show that it was more likely than not that KPK violated rules 905B and 906A. All right. Now I will, let me have just one moment to see if I can get my issue worked out here.
Sounds good, Ms. Rosenberg. We will pause your time until then. Ms. Rosenberg, I see your presentation up. Are you ready to commence?
There we go. I apologize. I wasn't able to unmute myself. That was my problem. So sorry about that. Thank you. Yes, and staff would like to call Chris Canfield as its first witness. Thank you. And thank you for indulging me there.
Can we elevate Mr. Canfield to panelist? All right. Looks like I see Mr. Canfield as a panelist. If he can unmute and turn on his camera, you can commence with your direct, Ms. Rosenberg.
Thank you. I don't yet see Mr. Canfield. Does anyone else? I don't know if it's my computer or not.
We can see him on our end.
Okay, I apologize for that. Good morning, Mr. Canfield.
Well, time out, Ms. Rosenberg. We see that Mr. Canfield is a panelist, and it looks like he is unmuted. I do not see his video on.
Sorry, that's what I was trying to clarify. Sorry.
Mr. Canfield, I see that you're a panelist. Are you able to turn on your video, or will you be proceeding without video? Okay, Ms. Larson is suggesting that perhaps Mr. Canfield should exit and re-enter the Zoom. We're not getting any audio or video coming out from him. So your time is paused until we can get Mr. Canfield up. Okay, it looks like I see Mr. Canfield as a panelist again. Looks like he is unmuted, and there is video.
I'm here.
Excellent. Ms. Rosenberg, looks like your witness is ready for you to proceed with your direct examination.
Thank you so much. Good morning, Mr. Canfield.
Good morning.
Thank you for joining us today. As a quick refresher for the commission, can you state your name and your job title?
Yes, of course. My name is Chris Canfield. I'm a COGCC Environmental Protection Specialist.
Thank you. And now I'd like to just ask you some general questions at the outset. Can you describe for me what, generally speaking, is a battery?
Certainly. A battery would be a group of surface vessels, flow lines, and other equipment that is being used for processing and storage of produced liquids, both hydrocarbons and produced water. And by processing, I mean a very preliminary separation of oil or condensate from produced water.
Thank you. And what is the purpose of a produced water vessel at a battery?
The purpose would be to provide temporary storage capacity prior to off-site disposal of the produced water.
Thank you. And now I'd like to ask you some general questions about the Grant Tank Battery. Where is the Grant Tank Battery located?
The Grant Tank Battery is located in Weld County, within the municipal boundaries of Frederick. It's near Legacy Elementary School, adjacent to a couple of public roads, approximately 50 feet from surface water in a mapped wetland.
And then what is this here that we're looking at in the red outline? Do you see that?
Right now, I only see your title slide.
Oh, you've not been seeing me switch over the sides. Oh, all right.
Nor have we, Ms. Rosenberg.
Okay. One moment. Let me see. What are you seeing now?
Again, I only see your title slide with the name and the NOAV number.
Okay, one moment. just a moment to confer with council to see if maybe one of them can present. And I apologize for this because on my end, it's showing that the slides are advancing. So one moment. Yeah. Ms. Larson, I am not sure what is going on with my technology right now. Would you be able to demote me? I can't even stop sharing to have Ms. Stafford share in my place.
Yes, we'll change you to an attendee and then we'll bring you back in.
Okay, thank you.
Of course. Ms. Stafford, I don't know if you're able to share your screen. Oh, okay. Ms. Stafford is able to share her screen. I don't know if she's able to advance the pages, however. We just still see the title page for the...
There we go. All right, thank you. And I'm ready to proceed now with Mr. Canfield. I apologize for this.
Please go ahead.
All right, thank you. So Mr. Canfield, let me, next slide, please. All right, Mr. Canfield, let's start back up here again. Can you tell me what the Grant Tank Battery is near?
So again, it is located in Weld County within the municipality of Frederick. It is immediately south of Godding Hollow Parkway. That would be the multi-lane road you see crossing your aerial photograph from west to east. It is north of Legacy Elementary School, which I see is labeled near the bottom center of the photo. And the road connecting Godding Hollow with the school, I believe that's Eagle Parkway, named after the mascot for the school. That would be the way students and faculty would enter the school.
Thank you. And is it near any wetlands?
Yes. I see outlined on the aerial photograph an unnamed stream. It's to the immediate west of the Grant Tank Battery. It's running more or less from north to south.
Mr. Chairman, if I may.
Mr. Jacobs, do you have an objection?
I wish to confirm the source of this photograph and the diagram that Mr. Canfield's referring to.
Yes, this is from Exhibit 5 for staff. We're just using it to orient the commissioners of the location and where the Grant Tank Battery is.
I would renew my objection previously raised, both to the hearing officer and previously, as portions of Exhibit 5 have been objected to by KPK. So I simply renew my objection. Nothing further. Thank you. But let me clarify that those objections were based on relevance, hearsay, and Rule 403. Thank you.
Thank you. Mr. Canfield, how old is the Grant tank battery?
One moment, Ms. Rosenberg. Can I confirm that this is a demonstrative piece of part of the testimony?
Yes, this is just to help visualize what we're talking about. It's just a demonstrative exhibit.
We'll continue.
Mr. Canfield, do you know how
Yes.
old the Grant tank battery is?
Yes, it's been there since 1978.
Thank you. And next slide, please. I'd like to specifically discuss what was going on at the Grant tank battery in 2019, specifically the ongoing remediation. Here we have the 2018 Form 27 for that KPK filed for the Grant tank battery. What information does this form give?
This particular form was short on details. Basically, as the subject work had not yet begun. As a result, no samples had been collected or submitted for analysis.
And can you explain the significance of the highlighted portions if you're able to read it?
Yes, I can read it. And in the highlighted portion, the operator is stating that at this point, at the time the Form 27 is being submitted, there hasn't been a spill or incident associated with the tank battery that could cause groundwater contamination which had been discovered and reported to us previously by the surface owner.
Thank you. And next slide, please. I'm just going to show some photos from the Grant tank battery to orient the commissioners as we talk. Did the Form 27 govern every activity that KPK might engage in at the battery at any given time?
No, it doesn't. The Form 27 process is iterative in nature. And so it allows for contingencies, revisions, amendments to take into consideration, respond to discoveries made while implementing the form. So for example, a form may not include details regarding an investigation of impacted groundwater until impacts are discovered, at which point in time the form would be revised or amended to provide details as to how an operator would propose to proceed with such work.
And then for a little context, why was that 2018 Form 27 filed?
Again, the COGCC had received a complaint from the landowner, the surface owner, in anticipation of implementing their plans for developing the subject property. They had hired a third-party environmental consultant to conduct a site investigation. The consultant had installed some temporary monitoring wells or observation wells. And during the course of collecting samples from those wells and analyzing those samples, they had discovered contaminated groundwater. That was the basis, if you will, of their complaint.
And so then did the commission ask KPK to file that Form 27? Or did KPK file it on its own?
No, we would pivot from our dialogue with the surface owner, the complainant, and notify KPK that we had received the complaint, provide them with the details, specifically in this case, a report of the findings of this third-party consultant, and direct them to
propose work via a Form 27 for further investigation to see if they could verify the findings of the third-party consultant. And indeed, if they did, proceed with work to determine what the source of the contamination was and the extent of the contamination, and ultimately to propose a remedy for contamination if indeed their work was to verify it's present.
Thank you. If I understand you correctly, then that Form 27 in 2018 is essentially it's like a snapshot of a moment in time regarding what information is available then. And does it then provide, does that Form 27 then provide notice for every activity an operator will engage in at that site?
No, it's very specific or surgical. It is simply asking for sampling and analysis to determine whether or not they can verify the allegation in the complaint.
Thank you. Next slide, please. Here we have Rule 905B as it existed in July 2019. Can you tell me a little bit about Rule 905B as it relates to produced water vessels?
Certainly. The rule basically states that produced water vessels, along with other types of vessels you see listed in the rule, shall be closed in accordance with an approved site investigation remediation work plan, the Form 27. So what we're requiring through the rule is if an operator intends to close such a vessel, that they allow us the opportunity, they're required to give us the opportunity to review and approve their sampling and analysis plan prior to commencing work. A plan designed to determine whether or not the produced water vessel has lost containment, or whether there could be a historic release, not necessarily from the current produced water vessel, but from a prior one. Again, I call you back to this tank battery had been in place and operated since 1978.
And how long approximately has the Rule 905 been in place?
Off the top of my head, it's been around as long as there's been a Form 27. So I would say 1998. It would have been in place roughly 20 years at that time.
So now going to July 1st, 2019, I'm going to ask you about your observations that day at the Grant Tank Battery. And could we switch to the next slide, please? Can you tell me generally, what did you observe on July 1st, 2019 at the Grant Tank Battery?
So I was conducting a investigation to basically to gauge the operator's progress with implementing their investigation. And as I drove up and parked, I saw that there was a piece of equipment and a backhoe there, as well as operators' personnel. The backhoe had been used to excavate around the partially buried vessel. It was a fairly large excavation. There was actually one person standing inside of the excavation, and there was ample room for this person to be standing between the wall of the partially buried vessel and the wall of the excavation. The depth was such that he was, I could really see only the top of his head, the top of his hard hat. I asked the KPK personnel to stop work and ask if the work was being done under an approved work plan, specifically if the Form 27 previously submitted and approved for other work at the site had been amended or revised to address the Rule 905 requirement. That triggered a series of phone conversations. The people on the location simply did not know. They made 2 different calls to their offices and trying to track down an answer.
Thank you. And can we switch to the next page, please? And let's talk a little bit about what you observed underneath and along the walls of the excavation. Can you tell me, what did you think and what did you observe?
Well, first of all, again, I would call your attention to the person within the excavation. That will give you using that person for scale, you get an idea as to how large the excavation was. And what I observed was impacted soil. It was stained. There was a very strong, discernible odor. Groundwater was infiltrating the excavation, and there was a sheen on the groundwater, and actually beyond the sheen, a separate phase of liquid hydrocarbons beginning to form on the water that was infiltrating the excavation.
And what did you tell personnel on site regarding this release?
Again, my interaction with them began with identifying myself and asking them to stop as I had questions. My questions centered on first, had they submitted a revised or amended work plan to address the activity I was seeing. I also asked about their spill reporting process. I believe they were discovering a release and asked, in such a situation, what is their internal process, their policy for relaying that information back to their offices and then subsequently notifying the COGCC, the property owner, and the local government.
Did you refer them to file a Form 19?
So the people I was talking to on the location, they simply didn't know what a Form 19 or a Form 27 was. They were certainly polite and courteous, but they could do little more than call their office and relay questions from me to the people they were speaking with. They made 2 such calls. It's not really clear to me who exactly they were speaking with during those calls.
Thank you. Okay, I'll move on a little bit here. Were you in Frederick, in that area where the Grant Tank Battery is, the week leading up to July 1st, 2019?
Yes.
Can we switch to the next slide, please? Do you remember any significant storm events in that week?
No. Certainly nothing that would dislodge a partially buried vessel, no.
Now, are you familiar with Exhibit 317? It's KPK's answer to this NOAV.
Yes.
And can you tell me read what that highlighted portion says?
KPK stated that the partially buried produced water vessel was not being removed, but had come dislodged during a storm event.
But to confirm, you don't recall any significant storm events?
No, actually, when I was first told that the vessel had become dislodged during a storm event, even though it was July of 2018, I assumed incorrectly that they were talking about the catastrophic flooding during September of 2013. And so I asked for clarification, and initially I was told that it could have been damage during the floods in 2013. Later, I was told no, there had been a storm event shortly before I got there. But as you see in the photos, the location was dry at the surface. There was no mud, no puddles.
Thank you. Can we move to the next slide? What we have here is the precipitation report for the area leading up in the week prior. Can you generally tell me what these highlighted provisions show regarding precipitation in the area the week leading up to July 1st, 2019?
I have to lean into my monitor. I don't see much. I see initially, I feel like I'm taking an eye test, but maybe a 1/100th of an inch, nothing. You know, I'm not seeing any significant precipitation events.
And when you were on site, did KPK personnel mention anything about a significant storm event the preceding week?
No.
And next slide, please. When, to your knowledge, did KPK mention a significant storm event causing the produced water vessel to be dislodged?
So upon returning to the office, I entered my inspection and the associated photographs. And in my inspection, I established some corrective actions, specifically a requirement to submit a Form 19 for the discovery of the release, as well as to amend or revise the Form 27 to address removal of the battery and sampling and analysis unique to that activity. I had subsequent conversations with KPK by telephone and email, and that's when I heard the idea that there had been storm damage, a precipitation event that floated the tank.
Thank you. Next slide, please. So I show these pictures a few times throughout, but these photos were taken July 1st, 2019. In your experience, what about these images suggest or don't suggest that there was a recent storm event?
The only moisture I see in these photos, the other inspection photos, the only moisture I observed that particular day was what appeared to be groundwater infiltrating the excavation.
And
the surface was bone dry.
Do you consider this produced water vessel to be floating up?
No.
And does it appear to be disconnected?
I believe it had been disconnected as part of other work taking place at the site. The work done under the Form 27 had been able to confirm that there were impacts to groundwater, and initially it wasn't clear to the COGCC or KP Kaufman what the sources of the impacts were. Initially, we, COGCC, myself, and other inspectors observed a release from a manifold, which we brought to the attention of KPK, and that manifold quickly, in a matter of days, was basically removed. There was also a flow line running to this particular vessel, which upon which a series of integrity tests were performed. It had failed 3 consecutive tests. And so at that point, we were aware of obviously issues with a flow line that had failed multiple integrity tests. We had witnessed the release from the manifold. Interestingly, the vessel that's shown in the picture, KPK had done an integrity test, a hydrostatic test of this vessel 2 or 3 months prior. I'd have to look at the record again to get the exact date. The hydrostatic test was witnessed by one of my colleagues, and the vessel had passed that hydrostatic test. So that's a snapshot. That tells you that on the day of the test, there were no issues with the integrity of the vessel. It tells you nothing about the 40-year history of that site.
Sure. No, I appreciate that. Thank you for that context. Talking though specifically about what you observed on July 1st, 2019, when do you consider the violation of 905B to have begun?
So in my mind, it would begin with the activity to expose and remove the vessel.
And can we switch to the next slide, please? And do you believe then when you observed this is when the violation began?
Yes, so what I observed was activity on July 7th that would have required prior approval of a unique standalone Form 27 or simply amending the existing Form 27 to address the battery.
You just said July 7th. Do you want?
I'm sorry, July 1st is what I meant to say.
Thank you. And
July
then
1st.
What would stop the violation from occurring in this instance?
Well, on July 1st, again, there's an inspection that reiterates to the operator the requirement for the Form 27 and establishes a deadline for performing the corrective action of either submitting a unique 27 for the partially buried vessel or modifying or amending the existing 27. So I would consider that, in my mind, that clock would stop when that amended form was submitted.
And are you referring to Exhibit 310 here, the October 4th, 2019 Form 27?
Yes.
And did anything on this October 4th, 2019 Form 27 jump out at you?
Yes. The first thing that, first of all, the submittal date. I had been hoping to see it much sooner than October. That was a lag of 3 months from the inspection and the dialogue the inspection triggered with KPK. But separately in the form, it was stated pretty clearly that the intention of the operator was to permanently close the partially buried vessel. Until I saw this form, what I was being told was that the plan was to expose the vessel for visual inspection, to respond to the vessel having become buoyant during a storm event, and so on and so forth. This was the first time there was an explicit statement that no, the plan is to remove the vessel, to close it.
Thank you. And now I want to talk a little bit about why this matters. I mean, what is the significance of KPK not filing the Form 27 here?
The significance would be that work could proceed, that we're simply unaware that the work is taking place. We, the COGCC environmental staff, not being notified that the vessel would be removed, not having an opportunity to review and discuss with KPK appropriate sampling and analysis for the purpose of determining if there was a reportable release, not necessarily a spill or release happening real time, but the discovery of a historical release. Again, we were in the process of trying to understand how it was that groundwater is impacted at that specific location. We were aware of at least a couple of spill release points, by no means had a complete picture of the entire location, its operational history, etc.
And do you consider this to be a major impact? And if so, why?
So a major impact to the environment is, I want to make sure I'm understanding your question. Yes, given the fact that groundwater had been impacted, given the proximity to the stream, the proximity to Godding Hollow Parkway, and as well as to the elementary school, yes.
Thank you. Next slide, please. Now let's talk about what you saw, the contaminated soil that you observed underneath the produced water vessel as it relates to Rule 906. And you can switch to the next page of the slide as well. Generally speaking, why does staff care if an operator informs the director, local government, and surface owner of a newly discovered spill?
Well, for starters, the notification to us and the corresponding reporting thresholds are required by rule. As far as the notification to the local government, it's not only required by rule, but required by statute. I believe House Bill 1278 established the requirement by statute to notify local government with responsibility for emergency response at the subject location. Reporting to the surface owner, again, required by rule, even though the surface owner had been the one who notified us of the discovery of contaminated groundwater.
Thank you. And next slide, please. Again, we have seen these photos before, but for purposes of Rule 906, tell me what this is.
So we're looking at into the excavation at the partially buried vessel, largely exposed. The worker is in the excavation with it. You can see in the photos discolored soil, impacted soil. You can see liquids beginning to infiltrate the open excavation.
And what's a smear zone?
So a smear zone results from a release of liquid hydrocarbons, which, because the hydrocarbons are, they're buoyant is basically what's happening. They are less dense than water, so ultimately there will be a separation in the subsurface. The hydrocarbons will float on top of the groundwater. Over time, there are seasonal fluctuations in the elevation of the groundwater. And as the groundwater rises and falls on a seasonal basis, it pulls or smears, if you will. The hydrocarbons floating on top of the groundwater are moved up and down, smeared through the subsurface. The result will be that you see an interval of soil that may or may not be saturated with groundwater at the time you're looking at that interval of soil, but it has nonetheless been contaminated by the seasonal movement, seasonal change in elevation of the groundwater and corresponding change in the where the hydrocarbons are located and in the subsurface with respect to the groundwater.
And why did you view this as a reportable spill or release?
Very simply, impacts to groundwater. The reporting threshold, if there are impacts to groundwater, it is a narrative threshold as opposed to a numerical threshold. So it is, the threshold will be any impact, any release, either impacting or threatening to impact waters of the state. And at this place, it was clear to me that the waters of the state had been impacted, specifically groundwater, and that surface water was being threatened.
And on July 1st, what did KPK relay to you that they were going to do with this spill?
So again, I want to distinguish between talking with people on the location who simply weren't even conversant with things like Form 27, Form 19, nor would I expect them to be, but with KPK staff. I relayed to KPK by phone from the location during the inspection that I would construe the conversation I was having with them as satisfying the requirement for COGCC to be notified within 24 hours of discovery, even though I was the one notifying them, if you will. But there would still be a requirement to submit a Form 19 initial report within 72 hours and a Form 19, and that as well the requirement to modify the existing Form 27, or if they prefer, submit a standalone to address this vessel.
Thank you. Next slide, please. So going back to the 2018 Form 27 for the Grant Tank Battery, did this form cover the spill that you observed on July 1st, 2019?
No, not directly. This is basically proposing what I would characterize as reconnaissance level work to initially to see if it's possible to verify the discovery made by the surface owner. And at that point, then there would be follow-on work to determine the extent of impacts, to identify sources and release mechanisms, transport mechanisms.
Thank you. So then KPK did need to alert the commission, local government, and surface owner of the July 1st spiller release?
Yes.
Even though staff was on site when the spill was discovered?
Even though there was a prior Form 19, we are keenly interested in understanding how spills and releases happen, and hence the requirement to notify the COGCC and when it's appropriate and required to do so, local government and the surface owner of the discovery of each unique spill release point, whether it's a discovery of an active spill or a historical release. And that information, it improves our understanding and the operator's understanding of what conditions are at the location. It helps us determine more fully the nature of the problem, the extent of the problem. But separately, our rules require not just identification of the spill release point, but information from the operator concerning the root cause of failure and actions the operator proposes taking to avoid a repetition of the problem. That root cause information is very important to us. It's part of an ongoing process to refine our rules, our policies.
Sorry for interrupting you.
Sure.
I wanted to go. So even if KPK had been in regular or semi-regular communication with the relevant local government entity, would this newly discovered spill still need to be reported to them?
Yes, it would. The rule is pretty clear. As a spill or release is discovered, they must be notified, period. Again, that's a requirement by not just by our rules, but by statute.
And then similarly, what about a surface owner? If KPK is in regular or semi-regular discussion with the surface owner about the remediation generally, would this spill still need to be reported?
If you're asking if it would need to be, if the surface owners would need to be notified, the answer is yes.
Yes. Sorry, I said yes, yes. And then next slide, please. What would stop the violation for the lack of notification to the relevant local government and surface owner from accruing?
Well, in my mind, it would be when the operator could confirm that they had made those contacts, that the notification had been provided. And in some situations, I would actually circle back to the surface owner or the local government to verify that indeed they had been notified.
Thank you. And now switching gears here a little bit, were you or are you aware of KPK's remediation plan with the spill that was discovered on July 1st, 2019?
Well, there was a modified Form 27 was submitted in October. And again, there had been multiple Form 27s submitted concerning this specific location. There was that initial one, which I saw on the screen as an exhibit. There was a subsequent one to which I applied a large number of conditions of approval that specified details, if you will, for an investigation.
And is the site investigation ongoing still?
Yes, it is ongoing. Just last week, I finished reviewing the most recent supplemental Form 27 submitted by KP Kaufman and added it to the record for this remediation project with some conditions of approval and review comments.
Okay, thank you. Now going back a little bit to the notice requirements as you see them, what if, so the parties, as you know, have stipulated that KPK has been the owner of record of the Grant Tank Battery, or operator of record, since December 31st, 1994. But even if this spiller release predated that, their own taking over of the being operator of record, would this spill still need to be reported, even if it wasn't caused by KPK?
Yes, I believe that the current operator of record is required to notify COGCC, and when it's required or appropriate to do so, surface owner, local government, of the discovery of historical spills and releases, especially in a situation where such a historical release could or is known to be contaminating groundwater.
And from your perspective, does an operator reporting a spill or release automatically mean that the commission believes an operator violated a rule?
No, it does not. It simply means that they have made a discovery and are notifying us of the discovery and beginning the process where we'll explore what happened, when it happened, what the root cause was, and if there are impacts, what will be done to determine the extent and correct them.
Next slide, please. And actually, next one after that, I apologize, not being operating sort of makes it up. So when is the last time you were at the Grant Tank Battery?
I haven't been there, I believe, since sometime during the first quarter of 2020, I believe February or March of 2020.
And taking a look here at this demonstrative photo on the right side, is that, just compare what you're seeing there to the water you saw on July 1st, 2019.
There's a lot more water in this photo, much more water in the excavation. Just looking at the photo, I would not be able to distinguish between, I assume it's a combination of groundwater having infiltrated the open excavation and stormwater, but I would have no idea as to what the ratio is.
Sure. No, and that's fine. And next slide, please. I just want to ask you, whatever came of the produced water vessel at issue?
Well, it was ultimately removed from that excavation, set off to the side. I believe it may still be stored on the site, on the surface.
And is that what we're seeing there in the photo on the left?
Yes. Yeah, I want to stress the two of my colleagues have been inspecting the site in my... Hello, I'm back. I'm sorry. I hope I didn't lose you. I had energy management time out here. I want to make the point that other COGCC staff have been investing in inspecting the site since March of 2020.
And did KPK ever show you the repairs that they claimed that they were doing on the produced water vessel, or show you on the water vessel what they had been trying to do that day?
No, I think it was after sitting in the excavation for months, it was ultimately removed and set off to the side, as you see in the photo.
Thank you. And just one moment while I confer here with council. Okay, at this time I have no further questions, and the staffer can stop sharing my screen. Thank you, Mr. Canfield.
You're welcome.
Mr. Chairman, I believe you're on mute.
Oh, there we go. Can everyone hear me now? I apologize. We're having some trouble with the mics here in the hearing room. We're about 11:13. We have a break scheduled at 11:15. So to honor that agenda item, we're going to go ahead and take our 15-minute break here prior to KPK's cross-examination of Mr. Canfield. So we'll go ahead and do that, give ourselves 15 minutes, and plan on coming back at 11:29 a.m. All right, I see all the commissioners. I see Ms. Rosenberg. Mr. Canfield was there. There he is. And I think we are ready for Mr. Jacobs to proceed with his cross.
Thank you, Mr. Chairman. With your permission, I do have a few questions for Mr. Canfield. Good morning, Mr. Canfield.
Good morning.
Thank you for being available to answer my questions. I just have a few. I believe you indicated that the landowner had provided some information to the COGCC in connection with its complaint about the discovery of contamination on the property. Is that correct?
Yes, sir, that's correct.
And then I think you also described generally that the COGCC then notified KPK of that complaint and the information that had been provided by the landowner's consultant. Is that also correct?
Yes, sir, also correct.
Thank you. I'm going to share screen with any luck. Bear with me. I believe you can see, hopefully, this Form 27.
Yes, I do see it.
Excuse me. That is not what I was going to show you. Now you can see a letter dated December 7th, 2018. Do you see that?
Yes, sir. Yes.
And that's to Mr. Mignol with BCL Colorado LP, the landowner, is it not?
Yes, sir.
And I believe this is the form of notice you were describing, this letter about the information provided by the landowner and the complaint and the data related to the discovery of contamination. Is that also correct?
It is. Again, I'm not immediately clear on the connection between the form you showed me and the letter. The reason being the Form 27 process is iterative. There have been multiple.
Sure.
submittals.
I apologize. I flashed that up prematurely. I'll be getting to that form in just a moment. So if we could take these exhibits one at a time and please just try to answer the questions I pose, if you would.
Yes.
Thank you. Do you see the highlighted portion here on the bullet at the top of page 2?
Yes.
Could you read that highlighted portion, please?
COGCC performed a records review of aerial photos, spill reports, remediation files, notices of alleged violation, well files, and inspection reports. No historic spills releases have ever been reported for this site.
Thank you. And then I believe the next bullet, if you could read that next highlighted portion as well.
Yes, KPK submitted a Form 27 to further investigate the extent and source of the groundwater contamination on November 14, 2018. And I cite the remediation project number.
Great, thank you so much. And then this form or this letter that I'm showing you, it's identified as KPK's Grant Exhibit S, lower right. Also copies Mr. Axelson. You work with Mr. Axelson, is that correct?
Yes, Mr. Axelson, pardon me, Mr. Axelson is my supervisor.
Great. And then Ms. Laura Mesa, you're familiar with her. She's the former VP of Engineering of KPK.
Yes, sir, I am.
Okay, so I think this closes the loop in terms of how the information in the complaint was then relayed by the commission to both KPK and others by Ms. Oakman's letter. Is that correct?
I believe there was communication between the surface owner and KPK, as well as communication between the commission and KPK in the form of inspections.
This letter is one such form of communication, is it not?
Yes, my point being it's one such form, but I don't believe it's the only such.
No, I understand. Please answer my questions if you would.
Yes.
I have a time constraint and I need to be efficient in my cross. With the permission of the chairman to please ask the witness to answer the question as best he can. If it is a yes or no question, I would ask that it be answered yes or no.
Understood.
Thank you so much. Now we'll go to that exhibit 302 that I prematurely flashed up there. You had, your counsel had previously displayed this as well. And this is the initial Form 27, is it not, that you spoke about?
Yes, it is.
Correct. And this was taken by Mr. Axelson, your superior, right?
Yes, sir.
And it was submitted, I believe, by Ms. Laura Mesa. And as you pointed out, it does point out that there's been no spill or incident associated with this battery that could cause groundwater contamination. That was your prior testimony, right?
Yes, sir.
Thank you. Are you, you don't know, do you, that Mr. Axelson never requested a Form 19 from Ms. Laura Mesa in connection with this Form 27? Did he?
I'm not sure if he did or did not. I don't know.
So you believe that Mr. Axelson could have requested a Form 19?
He could have requested a Form 19. I know he did request the 27.
Okay, we'll leave that there. I'm next going to show you Exhibit 305, and this is a supplemental Form 27 that was received, as you can see by the highlighting upper right, on March 15, and I believe it was taken by you. Is that correct?
Yes.
And this relates to the investigation of the site for historic contamination reported by the landowner, does it not?
Yes, it does.
And did you, in connection with your receipt of this supplemental Form 27, ever request a Form 19 prior to your investigation or inspection, excuse me, on July 1st, 2019?
So As of the time no, not as of the time of this form being submitted and approved.
Very good, thank you. You also testified about weather conditions, and I believe you pulled up some weather data. This is the staff's exhibit 306, I believe. Do you know the source of these data, the weather data in here?
No, sir. You would have to ask the Assistant Attorney General. I do not know.
Are you aware that the data from this made available through Weather Underground is from a person's personal weather station, like a residential or hobbyist weather station?
No, I'm sorry. I don't know what the source of this information is.
And are you generally aware that, you know, there can be sporadic showers in summer days in Colorado in most any month of June, including the month of June in 2019?
Yes.
Thank you. And then lastly, you ordered the workers to stop work on the tank, did you not?
Yes, sir, I did.
So their ability to complete the work that they were intending to perform was made impossible. Isn't that correct? They just simply had to cease.
No, that's not correct.
Well, they had to cease at that point in time. I'm not saying forever. I'm just saying you ordered them to stop work and they stopped. Is that correct?
They stopped for perhaps 30 to 40 minutes. That was it.
And do you have the requisite training to understand what causes a produced water tank to float up out of the ground? Are you qualified to render an opinion on that?
I believe I am, yes.
What is your specific training related to produced water tanks floating up out of the ground, and how does that qualify you to opine as to the cause of, well, let me withdraw that. We'll leave that where it is. I withdraw the question. I have no further questions on cross for this witness.
Thank you, Mr. Jacobs. Any
Yeah,
redirect?
I do have one clarification. I would note that for the record that staff stipulated that we stopped work on July 1st. That's a stipulated fact. Thank you.
Does Ms. Rosenberg have any redirect for this witness?
Just a couple of questions. Thank you. Mr. Campfield, did the 2018 letter that Mr. Jacobs showed you, Exhibit S, did that impact KPK's requirement to file a Form 19 for the spill you observed on July 1st, 2019?
No.
And another question is, would you have required KPK to file a Form 19 for a July 1st, 2019 spill in March of 2019?
So the trigger would be discovery of a spill, whether a release, an active release is discovered, or a historical release is discovered, a spill happens, what have you. It's the discovery. The requirement is keyed to the discovery date.
Thank you. And when did that discovery occur here?
So I have a clarifying question. Which discovery? Are we talking about the partially buried vessel, the flow line,
What we discussed in your direct line of questioning? When was that spill discovered?
I believe it was discovered on July 1st of 2019.
Thank you. And then did KPK crews resume work on July 1st, 2019?
Yes, they did.
And does a crew stopping work automatically mean that it has stopped work for all time?
No, it does not.
Thank you. No further questions.
Thank you, Ms. Rosenberg. Do we have any commissioners, any questions from commissioners?
Mr. Chairman, if I may, and I could do this after commissioner questions if you prefer, but I do have a recross question to follow Ms. Rosenberg's redirect, if I may.
let's stick to kind of how we've been doing things. So we'll hear from commissioners based on the direct, cross, and redirect.
Very good. Thank you.
Commissioner Messner.
Thank you, Mr. Chair. I'm just needing to make sure that I understand the timeline here. And so, Mr. Canfield, we've got an initial Form 27 on 11/14/18. We've got a supplemental Form 27 on 3/15/19. Is that correct?
Yes, sir.
Okay, and those were closed out, and the conditions of approval or the remediations that were suggested within those initial Form 27s were completed. Is that correct or not correct?
No, sir, that's not correct. It's an ongoing process, literally ongoing today. It's a highly iterative process. So you're referring to the initial Form 27 and the first in a series of subsequent Form 27s.
Mm-hmm. So if the initial Form 27 was on 11/14/18, and I think what I'm hearing you say is that it is not the situation, the remediation requirements within the initial Form 27 are not, have not been addressed to this date. Have the date requirements associated with the initial Form 27 been met? Has there been any violations beyond what we've indicated here on this July 1st date? Were there violations prior to that regarding failure to meet certain dates or failure to accomplish certain remediations?
No, there were not. And it's important not to somehow conflate the review and approval of a Form 27 for the purpose of adding it to the record for the project, which may involve applying conditions of approval and review comments. Approving one form out of a series of forms is a different matter from ultimately approving a request for a determination of no further action, which would end the project completely.
Okay, that's fair. That helps me understand the timeline and why we're looking at July 1st as kind of a start date on some of these alleged violations. And so that helps clarify me that there. So I appreciate that. And I will ask your opinion on something. So, I mean, having, heard testimony or read the pre-hearing statements and the indication that KPK is suggesting that this produced water tank that was at least halfway buried floated. I'm trying to picture a scenario where even a couple of inches of water would be able to create enough water underground to float a tank that's partially buried. And so I wonder, I mean, what does it take to move these things? From a hydrology standpoint?
It takes a lot. It would take an event similar to what was experienced during September of 2013.
Right.
It would not happen because of a typical summer thunderstorm.
Okay. Thank you. Well, that's the only questions I had.
Thank you, Commissioner Messner. Looking around for any other questions. Commissioner McGowan.
Thank you, Mr. Chair. Thanks for being here today, Mr. Canfield. I'm wondering, it's very easy to visually see the concerns about groundwater from the photos and the testimony. That hole is pretty deep, and I'm trying to follow kind of the thought process of the threat to the public road and or adjoining waters nearby, and how you thought about that. How you thought that might migrate or affect surface waters nearby or other sensitive receptors.
Given the proximity of the impacts to groundwater to surface water, during the supplemental Form 27 submitted by KPK early in 2019, I did require that they establish what is called a surface water station along the banks of the unnamed stream, so that we would have an opportunity to gauge or measure surface water elevation and determine if there is a relationship between fluctuations in surface water elevation in that stream with fluctuations in the elevation of groundwater in the wells being installed by KPK, and as well the wells installed previously by the surface owners consultant. The proximity to the street, the byway, it's based on simply whether you're looking at a map, an aerial photo, or literally standing there, you're quite close to Gotting Hollow Parkway. You're quite close as well to, again, I believe it's Eagle Road is the paved road that connects Gotting Hollow with Legacy Elementary. So simply put, it's proximity to potential receptors, whether it's the stream, Gotting Hollow Parkway, Eagle Road. I don't have a hard fast number, if that's what you're asking, as far as how do you know, is 30 foot a problem and 40 foot is not. There's no, that's part of the reason we do the site investigation. That's why I required collection and analysis of surface water samples, collection and analysis of sediments from the bank of the stream, gauging the stage of the stream so I could relate it to seasonal fluctuations in groundwater elevations.
Thank you, Mr. Canfield. I was surprised at the photo that showed such a significant amount of water that had filled the hole during some of those activities. So I was interested to know how the water all relates in that area and how things got filled or how they're all working together. Thank you.
Thank you, Commissioner McGowan. Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Mr. Canfield, for your testimony. I may have missed this, but what were the approximate ranges of depths of groundwater that the PISA meters showed? I'm not sure if I'm pronouncing that correctly, but
Piezometer.
Piezometers, thank you.
I don't have that information at my fingertips. As best I recall, roughly 14 feet, plus or minus a foot or two.
14 feet of depth.
14 feet below the ground surface.
Okay. And did I understand correctly that the ingress of groundwater that was apparent upon the excavation is sufficient to constitute a potential threat as you saw it to waters of the state?
Yes, there was initially a sheen, and ultimately a layer of, beyond simply a sheen, a layer of hydrocarbons on the water in the open excavation.
Okay,
So in other words, the water was in direct communication with hydrocarbons with the impacted soil.
Okay, thank you. And the stream that was approximately 33 feet or so away from the location, approximately what elevation was that in relation to the, or what, how much of a change in elevation was that from the location of the tank battery? Are you aware of the topography in that area?
I would need to check the records off the top of my head. I would not just know offhand the elevation of the stream, and I would also, the question would be time, related to time, that elevation or the stage of the stream varies on a seasonal basis.
Sure.
So it's one thing in August, and at other times it could conceivably be flooding.
Understood. Thank you. Is it, where is it positioned in relation to the tank battery?
So the stream is basically to the west of the tank battery.
Upslope, downslope?
Upslope, downslope. I would say cross slope, cross gradient.
Okay. Okay. Thank you. I appreciate that.
Thank you, Commissioner Nanjapa. Mr. Canfield, can you explain to me what cross gradient means?
Yes, that would mean at essentially the same elevation. The surface of the water would be lower than the surface of the location, but the relationship between the surface of the water and the groundwater surface is what can and does indeed vary throughout the year. Sometimes there's a connection, and sometimes the stream is gaining water from the groundwater. Other times it is losing water to the groundwater. And that's something that varies throughout the year on a seasonal basis.
And as the stream is kind of gathering or losing water from the groundwater, I'm just curious, how far does groundwater travel in order to affect that to affect that kind of taking and giving from the stream?
Not that far. Again, off the top of my head, 30 to 35 feet, certainly less than 40 feet.
Okay. Is there a thought here that the groundwater that was contaminated underneath the Grant tank battery, that was threatening at what I understand to be about 50 feet, the water in that stream, the unnamed stream to the west?
Yes, we were concerned in that we saw the release or releases resulting in impacted groundwater as presenting a threat to water quality in the stream. And part of the ongoing investigation is to determine if indeed such impacts are occurring.
And have any impacts been determined with the analysis thus far?
No, as of yet, we have not discovered any impacts to surface water in the stream.
Okay. Thank you, Mr. Canfield. I see Commissioner Messner popped up with the question, and then Commissioner Nanjapa.
Thank you, Mr. Chair. Mr. Canfield, groundwater is the water of the state, is it not?
Yes, sir, it is.
Okay, thank you.
Commissioner Nanjapa.
Thank you, Mr. Chair. Are you aware of the height of the stream bank versus the stream bed at that location?
Offhand, no. I would need to check our records and check the maps.
Okay, thank you.
Thank you, Commissioner Nanjapa. Any further questions from commissioners? Seeing none, and given kind of the process that we gave this last week in regards to a very brief and limited recross, I will give Mr. Jacobs an opportunity to ask a question.
Thank you, Mr. Chairman. And thank you again, Mr. Canfield. I'm going to share screen and we're going to return to Staff Exhibit 305. This is the March 15, 2019 supplemental form 27 that I showed you earlier. I'm scrolling to the bottom. Do you see that highlighted portion, the attachment checklist site investigation report?
Yes.
And you reviewed that site investigation report, did you not?
Yes.
And that would be this KPK exhibit for Grant Tank Battery K, dated the day before, March 14, 2019, did you not?
Yes.
And that report is reporting on soil borings and soil and groundwater sampling at the site in furtherance of the investigation required by Mr. Axelson in approving the initial Form 27. Is that correct?
Yes.
And do you see this highlighted language here on page 6, it looks like, of Exhibit K? Could you read that first highlighted portion?
Yes. Petroleum odors, gray to black staining, and VOCs were present in samples and cores collected from borings MW2, MW3, MW4, PB1, PB3, and PB4 at depths ranging from 4 to 15 feet below grade, below ground surface.
And the report also then indicates that samples from those borings were analyzed in a laboratory and found detections of BTEX, gasoline range organics, and diesel range organics. Is that correct?
Yes, that's correct.
And yet you still did not require a Form 19 be submitted in connection with your review of this supplemental Form 27. Is that correct?
Have to check to be sure of. As best I recall, no.
I represent to you that we're certainly not aware of any Form 19 that you required or requested as of the approval or receipt rather of the supplemental Form 27 staff exhibit 305. No further questions on redirect. Thank you, Mr. Chairman. Or recross, excuse me.
Thank you, Mr. Jacobs. I think we.
I would just like to assert one thing quickly here, and I apologize, I don't have the stipulated fact number before me, but the parties did stipulate, quote, based on the analytical results for the soil and groundwater samples collected, petroleum contaminated soil and groundwater exceeding COGCC standards are present at the property. And that was stipulated fact number 17. Thank you.
Thank you, Ms. Rosenberg. We're going to go ahead, I think, and move on to the next witness. So, Ms. Rosenberg, if you are ready to call your next witness, we are ready for you.
Yes, thank you. And this should be a quicker witness, just for everyone's information. We'd like to call Jeremy Farron.
Good morning, everyone. Can you hear me?
Yes, we can.
Thank you, Mr. Farron. Can you just refresh the commissioners your name and job title just for their edification?
Yeah, Jeremy Farron, Enforcement Supervisor at the Commission.
And sorry, one second, trying to see if Ms. Stafford might be able to share a particular document here as we discussed, but I will go ahead and get started, and then we can get the claims table document up when it's ready. Can you touch on the alleged storm event and the concept of force majeure and how it would apply here?
Yeah, so there's obviously a disagreement between staff and KPK as to whether or not force majeure applies here. Had we thought force majeure applied, we might not have even issued the NOAV, but since it's been issued, it's now up to the commission to decide whether they believe that counter argument. But I want to note that force majeure is actually listed as a mitigating factor in 525. And so I'm not sure force majeure, where an NOAV has been issued, is appropriate for dismissal as opposed to like a mitigating factor and a penalty adjustment.
Thank you. And then what about the idea of whether KPK was the responsible party or not for the historical spill that was discovered on July 1st, 2018?
Yeah, so I think we talked about this. Rule 526 requires KPK to put together some credible evidence to support that contention. I think that's going to be hard here, given the stipulation that they've been in charge of this property since 1994. But regardless, I think staff has been pretty clear that even where historic contamination is an issue, or at least an alleged issue, they still expect people to comply with the rules, including 905 and 906. But ultimately, if the commission decides that that argument has merit, we would ask you to treat this like you did NESU 1, which was a percentage reduction of, I think it was 33%.
Thank you. And then both on this claims table, you can see that both rules 905B and 906B are listed as class 2 rules. Any thought given to reclassifying those in this instance?
I think I've said this 5 or 6 times now. We considered it, but we did not, given the fact that they'd been classified for so long and there was no clear reason to differ from the classification here.
Thank you. And then with regard to 905B, the impact of the rule has been classified as major. Can you describe why you chose not to allege it as a minor impact or moderate?
Yeah, so we allege the failure to receive prior authorization directly related in the impacts that were observed here. We talked about the distance to the nearby waterway, the impacts in the soil, in the groundwater, in the the hole that was there. And if the contaminations to groundwater and soil, if it's not significantly adverse impact, which is the major, we think at the very least it still needs to be moderate, because there were in fact actual impacts. And in fact, classifying it as minor along the lines of what I think KPK is suggesting would violate 525.
And then in KPK's opening, they touched upon an argument about waiting for staff to provide more information, and that the days of violation, while KPK was waiting for that, I believe it was 23 days, should be removed from the penalty calculation. What is your thought on that?
So that's something that we would have considered. I think here the facts don't support that. I think it was a request for staff to sort of withdraw a directive, and ultimately that directive was not, we did not withdraw the directive. We still wanted them to file. And 525B5, which is what I think they're getting at, but I don't think they cite that rule. It talks about a good faith, discussion with staff about, something, and not having the penalty clock ticking at the same time. I think this is a different situation. They essentially said, no, we're not going to do that, and staff eventually disagreed with that decision. I don't think that's a good candidate for a withdrawal of those 23 days.
And then finally, what about the duration that you came to for the Rule 906B violation? How did you come to that, and did you consider any counter evidence provided by KPK in that regard?
So this is a counter argument they've made in a number of cases where they're suggesting a 1-day violation for the due date of the form or the notice or what have you. And this commission didn't find that argument compelling, and I think it was in Gilson. And I would ask that they do the same here. It should continue for the length of this duration, especially given 525's mandate of individual penalties for each day.
Thank you. I have no further questions at this time.
Thank you, Ms. Rosenberg. Mr. Jacobs, Cross.
Thank you, Mr. Chairman. No questions for this witness on cross.
Questions? I assume no redirect, Ms. Rosenberg? All right. Any questions from commissioners? Mr. Messner.
Thank you, Mr. Chair. Thank you, Mr. Farron. KPK indicated in their pre-hearing statement that this was a novel application of Rule 905B. In your experience, is this a novel application of Rule 905B?
I actually can't answer that. I think that might have been a better question for Mr. Canfield. We could bring him back, but I don't think I've ever seen an instance of 905, and that doesn't mean that there aren't a number outstanding. But this is the only one I've become intimately familiar with.
Okay. Thank you.
Any further questions from commissioners? Okay, I think that's it. And I think, Mr. Farron, you are dismissed for now. Ms. Rosenberg, next witness.
That concludes our presentation of our case in chief. I do have a mini closing, and I could offer that up now or whenever you prefer.
Why don't we do that now?
Sure, thank you. Thank you, commissioners. Your job here is actually pretty simple. You really just need to decide two things. First, you must decide whether it was more likely than not that KPK was removing the produced water vessel on July 1st, 2019, when KPK had excavated entirely around the vessel and hooked it up with a chain to a backhoe, and ultimately removed the vessel. It is more likely than not that KPK was removing the vessel in contravention of Rule 905B, and KPK was not performing maintenance, routine maintenance, as the evidence supports that they were removing it. You must also determine whether KPK needed to report the July 1st, 2019 spill or release. They did need to report it. The commission staff and local governments need to know about all discovered spills for a variety of reasons, from protecting groundwater to being able to respond in an informed manner when a member of the public asks about a spill. In addition, surface owners have a right to know what's happening on their property, regardless of whether they have a general awareness of the ongoing remediation and regardless of when the spill may have actually occurred. Whether the spill was old or new, caused by KPK or not, KPK needed to report it upon discovery and follow through with all of the Form 19 requirements. The standard is simply whether it was more likely than not that KPK violated these rules. The evidence in the record and the evidence provided today support a finding of violations of Rule 905 and 906. Thank you.
Thank you, Ms. Rosenberg. Mr. Jacobs, you going to use any time for an additional cross at this time? I mean, additional close at this time?
Mr. Chairman, I believe our mini closing comes at the end of our
Sure,
defense.
that's correct. That's my mistake, Mr. Jacobs.
Thank you.
Okay. In that case, I think it's appropriate for Mr. Jacobs to bring his first witness for KPK's case in chief.
If you'll permit us a few minutes to get our first witness, will be Mr. Jeff Peterson into our witness room. We had thought perhaps you'd be taking a lunch break soon, but we're happy to get started now if that's your desire.
Well, that's, we've got 20 minutes before our lunch break. We just came off of a 15-minute break. I'll look to my fellow commissioners if there's any interest in pursuing this, getting through at least this witness or the direct of this witness prior to lunch. Seeing nods all around, so let's proceed.
That's fine, thank you. I believe KPK witness room is elevated, and we're just awaiting Mr. Peterson getting situated and turning on video there. So we'll get started as soon as he's up. Looks like we have two KPK witness rooms. I appreciate that one of them has Mr. Peterson. Mr. Peterson, can you hear me?
Yes, sir, I can.
Okay, great. And the audio sounds good as well. Mr. Chairman, with your permission, I'll proceed.
Please.
Mr. Peterson, welcome back to the hearing, phase 2. I believe you previously testified that you are a roustabout supervisor for KP Kaufman Company. Is that correct?
Yes, sir, I am.
And you've worked as a roustabout supervisor for KPK for how long?
A little over 16 years.
Great. And I believe you said you have a high school diploma and a few years of coursework at the college level in construction management. Is that also correct?
Yes, sir, that's correct.
You heard testimony of staff earlier this morning that regarding the Grant tank battery, correct?
I did.
Great. And do you agree with staff's allegation that the KPK roustabout crew at that location on July 1, 2019 was removing a partially buried vessel that you'd intended to remove it permanently?
No, I don't agree with that.
Why is that?
Because in that morning I had called in an 811 emergency locate. And I had noticed that the vessel in question had been displaced.
And did you notice that the vessel had been displaced? Was it that morning?
I had been working in the area the previous week around Friday. And I had noticed, the tank being a little bit it was displaced.
Okay. And so that was the basis for your 811 locate?
Yes, sir, it was.
And you had to do that to safely, what were you intending to do regarding the tank? What did you instruct your crew to do regarding the tank?
I instructed my crew to go over and excavate around the tank in order to reset that tank.
Did you, let's see, do you know what caused the tank to float up out of its earthen foundation?
I'm not entirely certain, but I do know that the tank had been emptied, and when that tends to happen, it becomes a little more buoyant.
Right.
And,
okay. So you covered that. And was the tank battery operational at that time? Do you know?
at that time, no, it was not.
Do you know when it became non-operational?
I believe it was around May 3rd. Noticed that that's when our production stopped.
Okay. And how do you know that?
I had talked to our production manager at the time, and he had shown me gauge sheets from that.
Okay. Do your roustabout crew members have responsibility for filing any forms with COGCC?
No, sir, they do not.
Do you have any responsibility for filing forms 19 or 27 or other forms with COGCC?
No, sir, I do not.
Who does that for the company?
Max Nopp is the one that is responsible currently for that, and I believe Miss Laura Mesa at the time was also in charge of that.
And if your crew was removing the PVV as alleged, did they even have the equipment necessary to do that on July 1st?
In order for us to remove that tank off location, it would have required a trailer, and that crew did not have a trailer at the time.
And as roustabout supervisor, is it your job to make sure that they have the equipment necessary to perform scheduled tasks?
Yes, sir, it is.
So if you'd intended to remove the trailer, you'd have had remove the tank, you'd have had a trailer dispatched to the location. Is that correct?
Yes, sir. I would have asked the crew to bring a trailer with them so that they could load that up and take it off location.
I have no further questions for this witness at this time.
Cross from staff.
I guess thank you. So you said the produced water vessel in question was displaced on July 1st, 2019, right?
Yes, ma'am, that's correct.
How was it displaced?
Just on a visually looking at it, it was listing to one side, meaning that I guess from a directional point of view, the south side of the tank had lifted, and you could visually see that the tank was leaning to one side.
And this is while it was still in the hole?
Yes, ma'am.
And did you take any photos of this?
I did not know.
Do you typically take photos when you see something that's become disconnected?
Not normally, no. Not then.
And then how could you tell that it had floated up?
From my experience, I've seen fiberglass tanks that have floated due to one event or another.
So you said that to remove it, you would have needed a trailer on site, right?
In order to remove the vessel from off-site, yes.
And you know that vessel is still on the site today, right?
Yes, ma'am, I believe it is still on site.
So did you ever get a trailer to remove it off the site?
No, it was never the intent to remove it off the site.
Okay. And what is your policy internally at KPK for communicating newly discovered spills to Mr. Dopp, since he's the one who knows how to report them?
Whenever we find anything, any contamination or anything like that, I notify my production manager, and that goes from the production manager to Max Knopp.
And what would your crew have done on July 1st had staff not been there?
They would have notified me about the contamination.
And what would you have done?
I would have notified my production manager and told them we have some contamination there.
Would you have expected Mr. Dopp then to have filed a Form 19?
I can't speak to that. I'm assuming that's the chain.
And generally speaking, do your roustabout crews have a general knowledge of commission rules?
No. No, not really.
Then how would they have known that that contamination was something they needed to report to you?
Because it's common practice for us that if you see something, let someone know.
Okay. At this time, no further questions. Thank you.
Redirect Mr. Jacobs.
Yes, with your permission. Mr. Peterson, I believe you indicated that prior to July 1, you were in the area and had observed the tank dislodged. Is that correct?
Yes, sir, that's correct.
And then on the morning of July 1, you called in an emergency 811 locate to safely begin the work that your crew was tasked with. Is that also correct?
Yes, sir, that's correct.
So approximately what date did you first observe the tank listing to one side as you described for Ms. Rosenberg?
I was in that area around Friday. I believe it was June 28th, I believe.
Okay. Thank you for that clarification. No further questions on recross or redirect, excuse me.
Thank you, Mr. Jacobs. I've got one question I'll start off with. Mr. Peterson, walk me through the operational process of removing a tank.
Are you speaking of removing the tank permanently or just to do maintenance?
Permanently. So assuming you were removing this tank, what would have been the process that you would have undergone?
I would have excavated around the entire tank, disconnected any inlet lines going into the tank, and then my crew would have, chained off the tank and lifted it out of the excavation, and then loaded it onto a trailer and chained it down and hauled it off.
So what I'm getting at, I guess, aside from lifting it out and putting it on a trailer and hauling it off, were all the steps kind of the same involving the excavation, the digging around the tank that occurred on this tank battery?
Yeah, pretty much. I mean, in order for us to investigate, to reset that tank, we would have needed to excavate around that tank, cleaned out any soil that could have gotten in there underneath the tank, and cleaned that out, and then set the tank back into the hole and reconnect any lines that were running into the tank.
In your experience, in terms of, you observed that the tank was listing to one side, and that from experience, you've seen that happen before. How long does a tank usually sit empty before that happens?
It kind of varies, but it depends on the amount of water that could be in the area. I know in that case, I believe that the tank was pulled down to 1'6". 1 foot 6 inches was left of water in the bottom of the tank, approximately. And, whenever, if there's any rain or anything like that gets in around that tank, it'll lift it. It will lift it.
Okay. Thank you, Mr. Peterson. Questions from other commissioners? Commissioner McGowan.
Thank you, Mr. Chair. Thank you, Mr. Peterson, for your testimony. So if you saw it listing the week before, you waited till the following Monday to make the 811 call. Could you explain why you waited and you didn't think that it was urgent to check it out and find out what was going on?
Well, when I saw the tank, it was listing to one side, but it wasn't a drastic, it wasn't in comparison to other tanks that I've seen, it was a little on the minor side of it. And then I stopped and I looked around location to see if there was any, you know, anything to release or anything like that. And I didn't notice anything. The berms were still in place, you know, and so at that time to take immediate action, I didn't feel that it was necessary, especially with the fact that, you know, the battery was not operating at the time.
And then, thank you. And so could you explain to me why the tank is sitting on site and that it wasn't, in fact, in the end, taken off site? I think I'm a little perplexed by that.
I think, and you know, with pardon my rudimentary, you know, language, but our intent is to put the battery back into production once the remediation is done. And that would include reinstalling that fiberglass tank.
So, sorry. So therefore, if you're going to reinstall the tank, if there has been an historic leak, it wouldn't have been from the tank because the tank then is in good enough condition to put back in the ground and use again? Sorry, I'm trying to understand.
No, prior, I believe, and you'd have to confer with the other witnesses, but there's an integrity test that was done on the tank. So, and to my knowledge, that tank is still in good shape.
So maybe another witness can help me understand where we think the leak is coming from. I think I'm not quite catching something.
From my knowledge, there really wasn't a leak. We didn't notice anything leaking from the tank when we initially investigated it. To my knowledge, this is just historical that was there prior to us digging up that tank.
Sorry, I'm still trying to connect dots.
Mm-hmm.
I've heard testimony today that there was a sheen on the water, and you can see in the pictures there's kind of staining around that. So if there has been some sort of historic, I'm trying to figure out where the historic thing came from. Did we ever discover where that's from?
I don't know. I have no idea where it came from.
Okay.
Mr. Chairman, if I may, we do have some other witnesses coming that I think will be able to answer the commissioner's question.
Thank you.
Thank you. Commissioner Messner.
Thank you, Mr. Chair. You may have said this already, but I just want to make sure my notes are clear. When was the last time that this tank was full?
I believe the tank was actually pulled down to 1'6" sometime in May. I can't nail down a specific date, but with the production reports that we had from May 3rd, I believe that tank would have been pulled down to that level sometime during the month of May.
Okay. And in your experience, I mean, as I look at a tank and as a lay person, I mean, there's two different ways that a tank can tilt, right? One is by floating, one's also by degradation of the other side, right? I mean, I imagine that it can go both ways. I mean, is floating the only possible reason that a tank could tilt, or could it be groundwater or something happening underground on the other side that may have one side drop? You know what I'm saying?
I mean, it's possible if groundwater were to rise up or you know fluctuate with the tank being that buoyant. I would assume so. Yeah, there could be another reason other than a rainstorm, I suppose.
Thank you. I appreciate that, Mr. Peterson.
Looking around for additional questions. All right, seeing none. Mr. Jacobs, do you have a brief redirect for us?
I have no further questions for this witness. Thank you.
All right. With that, we will dismiss Mr. Peterson. And looking at the clock, we're at 12:26. I'm afraid we may get too far into the lunch hour with the next witness. So we'll take our lunch break here. We'll take 45 minutes, come back about, what we'll call it 1:10. Sounds good. We'll see y'all back there. Okay. Welcome back, everybody. I'm trying to get my panel set up here, make sure I can see all of my fellow commissioners. Looks like everybody is in. So now that we're returning from lunch, one thing I wanted to daylight and to draw attention for council is that there may be additional questions for some of the witnesses we've heard from thus far by commissioners. And I think it's important that if we are going to recall those witnesses, that we try and do so before the close of this NOAV, in particular for this Grant tank battery. So if council could let their witnesses know that they may be recalled, likely later this afternoon, if at all. So just wanted to put everyone on notice for that. Thank you, Ms. Rosenberg. I see a nod from Mr. Jacobs. Okay, so that being said, I think we are ready for Mr. Jacobs to call his next witness.
Thank you, Mr. Chairman. With your permission, the respondent will call Max Noav as our next witness.
We will get Mr. Noav. Well, it looks like the witness room is elevated to panelists, so we will wait for that. There we go. I see him.
Max, can you hear me?
Yeah, can you hear me?
Yes, thank you. Very good. Welcome back to phase 2 of the hearing, Mr. Noav. I believe you previously testified that you're the Director of Environmental Compliance for KP Kaufman Company. Is that correct?
That's correct.
And you've held that position for 7 years, I believe. Also correct?
Yeah, that's correct.
And you testified you have a bachelor's degree in geology from the University of Colorado.
Yes, that's correct.
And you were an air quality consultant after college for several years with LaSerre Environmental prior to joining KPK as its air quality manager. Is that correct?
That's correct.
Very good. Thank you. Do you know Ms. Susanna Laura Mesa?
Yeah, she used to be my former boss at KP Kaufman.
And is Ms. Laura Mesa still working with KPK?
No, she took a different position a couple years ago.
Okay. Was she involved initially in addressing a complaint regarding the Grant tank battery and some possible contamination?
Yes.
Who submitted that complaint?
That was submitted by the landowner.
Very good. And how did KPK learn of this?
We received a letter from the COGCC notifying us of the complaint.
And is that the letter I showed Mr. Canfield earlier, KPK Exhibit S?
Yeah, that's the same letter.
How did Ms. Laura Mesa respond to that letter? Do you know?
She filed a Form 27 to begin our internal investigation, our own investigation of the complaint.
And that was the prior Exhibit 302, I believe I showed Mr. Canfield as well. The November Form 27 that was filed by Ms. Laura Mesa?
Yes, the one that was filed, 2018, November.
Great. Did KPK perform integrity testing on the partially buried vessel at the Grant tank battery as a result of the complaint by the landowner?
Yeah, we did a 48-hour hydrostatic test on the produced water vessel.
Why did you do that test? Can you tell us?
That was to verify the integrity of the vessel. It was also not a COA, but a comment from an approved, prior approved Form 27.
Okay.
And what were the results of that test?
The results, it passed the integrity test. The tank had integrity.
Bear with me, I'm going to share screen here for a moment. Okay. No. 303. Very good. We'll share. Can you see that form, inspection form? Dated,
No, Mr. Jacobs, we can see your desktop.
Oh, I apologize. We will stop share. Let's try that again. Screen 2. Share. Thank you, Mr. Chairman. My apologies. You can see this form, inspection form now?
Yeah, this is a field inspection form.
Right, and date March 6 and March 8, 2019.
Yes.
And I believe Mr. Canfield and Mr. Schlagenhoff are identified as the contacts for that inspection.
Yes.
And you see the highlighted portion here that they were there to observe integrity testing of that produced water vessel. Is that correct?
That's correct.
And then further down here, we have a comment that indicates that 48-hour test was performed. I'm just paraphrasing, and the test result was deemed satisfactory. Do you see that?
Yep.
Very good. And did KPK do further investigation regarding the benzene detection that was first reported by the landowner in their complaint and the accompanying report of its environmental consultant?
Yeah, we hired Apex Consulting, Mike Cattle, to perform our own phase 2 assessment of the location.
And did Apex prepare a report of that investigation?
They did.
And is that the report that I showed Mr. Canfield, Exhibit K, KPK Exhibit K, dated March 14 of 2019?
Yes, that's the report.
And what did the Apex Phase 2 report indicate?
It identified significant subsurface impacts at the grant location.
And that was based on both soil and groundwater sampling and analysis?
That's correct.
What did KPK do with that report?
It was immediately submitted with a Form 27.
And that was the Exhibit 305, I believe, that Mr. Canfield was shown and that staff also utilized as an exhibit?
Yeah, it was the March 15th, 2019, Form 27.
Supplemental Form 27?
Yes.
What else did KPK do to investigate contamination discovered by the landowner at the Grant Tank Battery?
We asked Dolan Integration Group to perform a forensic analysis.
And you see, what sort of analysis is that? Can you describe what that forensic soil analysis was?
Yes, we were trying to compare the oil that's produced at the location and compare it with the oil the media that's associated with the contamination that was identified in the phase 2 assessment.
And I'm going to share screen again, hopefully the right screen. Let's do this again. You see what we've marked as KPK Grant Exhibit N?
Yes.
And is that the Dolan Integration Group report that you asked for to compare oil and soil samples from the Grant Tank Battery location?
Yes, that's the report.
What did the Dolan report indicate?
It identified that the source and contamination is the same oil that is produced at that location.
And were the soil samples used for this Dolan comparison from the soil borings that Mr. Haddle obtained for you for his phase 2?
Yes, they were from the borings.
Great, thank you. Let's see, turning now to the inspection of July 1, 2019. You've heard staff's allegations and seen their forms in NOAV indicating they believe KPK was removing the partially buried vessel at the time they arrived on location. What work was going on when staff arrived at the location?
They were repairing that partially buried vessel, resetting it.
Okay. And is this the same partially buried vessel that the integrity test, on which the integrity test was performed in early March we just spoke about?
It is the same one.
So was this tank the source of any contamination, you believe?
No, based on the integrity test, it was not.
Very good. Let's see. Did you review weather data for this time period preceding the July 1, 2019 inspection in preparation for this hearing?
Yes.
And I'm going to pull up exhibits G and H with any luck. But I have them open. Bear with me.
And I'd like to note that staff objects to the use of these exhibits as they are irrelevant because they refer to Loveland weather history.
Mr. Knopp, I'm showing you exhibit G, KPK exhibit G. You see that's indicates Loveland, Colorado weather history?
Yes.
And scrolling down.
Mr. Jacobs, I'm sorry for interrupting you. I think I'd like to hear you respond to Ms. Rosenberg's objection.
Absolutely. I think it's relevant. We believe that weather may have contributed, been a contributing cause to the dislodgement, the floating, or whatever the cause was of the tank listing to one side and needing maintenance work, as testified to by Mr. Peterson and also Mr. Knopp. So I think it's relevant. Moreover, weather data can be the subject of administrative notice under the commission's rules. Specifically, I believe it's Rule 517. I had the subpart here a moment ago. And that the subparts of that rule also incorporate by reference the ability of a court, Colorado State Court, to take judicial notice of reliable information, technical and scientific information, or weather being a classic example of things, past weather events recorded reliably that a court and this commission can take either judicial or administrative notice of. So whether or not, so I think it's relevant. I think it certainly can be admitted into evidence by the commission. I would ask you to consider it.
I also want to just re-explain, this is for Loveland, Colorado. We're talking about the Grant Tank Battery, which is miles away from Loveland. And I also note that this is the same weather source that Mr. Jacobs suggested was unreliable earlier today when we presented weather related to the location where the Grant Tank Battery actually is.
Thank you, Ms. Rosenberg. I think that we can, we understand what's being presented to us. I think we understand the location that's being asserted for this weather report. And I'll also note that the weather report submitted by staff was for Firestone, Colorado. We understand this location to be in Frederick, Colorado, and we as commissioners can look at that and evaluate that evidence as we see fit.
May I proceed, Mr. Chairman?
Please.
Thank you. So scrolling down to this middle graph on above the word summary there that shows precipitation and precipitation average, do you see how the precipitation line comes up pretty sharply beginning June 21?
Yes.
And unfortunately, this information is truncated. So I'm going to next go to, let's see, Exhibit H, which is the next set of data from the same source. And then from June 23rd here to the lower left, you see it peaks and then comes back down as of June 25th, indicating precipitation across those days, June 21 through 25. Is that correct?
That's correct.
Very good. Close that out. And have you had occasion to review other area weather data in that time period?
Yes.
And did you note any other significant weather events in the days and weeks prior to the observation by Mr. Peterson that the tank had become dislodged?
Yeah, I mean, there's a variability of weather data available. You could look at the same type of data that was presented earlier from personal weather stations. There's other personal weather stations that report significant weather throughout precipitation throughout June of 2019. There's also DIA weather station, which is more accredited than a personal weather station monitor. And that shows precipitation throughout June. Not continuous, but multiple days of precipitation.
Thank you. And did the dislocation of the partially buried vessel reveal contamination beneath the tank?
Yes.
Was that indicative of a release from the tank?
No.
What do you believe to be the source of that contamination?
That was a contamination that was already identified through the phase 2 assessment the Apex Consulting conducted.
And the landowner's consultants investigation as well?
Yeah, and prior to that, their own phase 2 assessment of the Hinkley Farm area.
So how did you respond to staff's direction to KPK as a result of the July 1st, 2019 inspection and their apparent belief that this was new contamination or a new spill or release?
Form 27 was filed providing communication of understanding of the contamination and correlating it back to the known historical contamination in the area.
And I'm sharing screen, the Form 27 supplemental that you filed the day after the inspection on July 2nd?
Yes.
The record indicate that's KPK, actually staff exhibit 309. And did this form indicate KPK would begin excavation of the contamination discovered by the landowner and further delineated by Apex?
Yes, it did.
And was staff satisfied with that response?
No, they weren't.
Is that because they were requesting a new Form 19?
Yes, they wanted a Form 19 to report a new spill for the contamination observed under the produced water vessel.
Even though previously, as I believe we established with Mr. Canfield, Ms. Laura Mesa had submitted a Form 27 many months prior in November of 2018 to Mr. Axelson. He received it and didn't request a Form 19, did he?
No, the observed contamination was already the subject of the Form 27s that have been submitted multiple times.
And then Mr. Canfield received your March 15, 2019 supplemental Form 27, and he still did not request a Form 19, did he?
No, and within that Form 27, that supplemental Form 27 was the phase 2 assessment, which could identify the known area of contamination around the produced water vessel.
Did you eventually submit a Form 19 and a Form 27 in response to Mr. Canfield's requests?
Yeah, at staff's direction, those 2 forms were submitted.
And that was what, October-ish?
The Form 19 was submitted in July, and then the Form 27 for the closure of the partially buried vessel was submitted in October.
Okay. And in these forms, did you indicate that the contamination was historic?
Yes.
Concerning the alleged 905B violation for failure to submit a Form 27 before closing a partially buried vessel, do you dispute that violation, and if so, why?
Yes, I dispute it. We were, one, not removing it, and two, there was no plan for closure of that vessel.
Okay, thank you. And with respect to the alleged violations of rules 906(b)(2) and 3 concerning notice to the surface owner and to the local government designee, you dispute those violations, and if so, why?
I do. Regarding the surface owner, they were the ones who identified the contamination and filed the complaint. They're aware of the known historical contamination. Regarding local government communication, the contamination that was observed on July 5th was associated with the contamination that was already being discussed on previously submitted Form 27s.
I believe you said July 5th. Did you mean July 1st?
No, July 1st, yes, I'm sorry.
Yeah, thank you. Just wanting to keep the record clear on that. Finally, there's the alleged failure to report a spiller release in 72 hours and again in 10 days under Rule 906(b)(1). You dispute that alleged violation?
I do.
And why?
It was not a new release, a new spill, on new contamination that was discovered. It was all associated with what was initially being reported previously, again, with multiple Form 27s.
Thank you, Mr. Noav. I have no further questions for you at this time.
Ms. Rosenberg?
Thank you. Good afternoon, Mr. Noav. I just have a few follow-up questions for you. Were you at the Grant Tank Battery on July 1st, 2019?
No.
Were you aware of what was happening in real time as it was occurring?
No.
So I thought Mr. Peterson said that can you describe the chain of command for me again? How was it decided that that work would commence that day?
Yeah, Mr. Peterson was describing the process to reset the produced water vessel, to repair it, not report it for removal.
Right, and can you describe though that process for me again?
For removal or for repair?
Either way, how was it communicated that day? Who made the decision to go on site? How did that occur?
Well, as discussed earlier, Mr. Peterson identified there was potential issue with the produced water vessel, and then repair work was scheduled for that following.
And how did that get scheduled exactly?
That was through our field operations.
And who's that?
I mean, that was handled by Mr. Peterson.
So he made the decision unilaterally to commence work that day?
Yeah, to repair and reset the produced water vessel.
And when did you become aware of it?
I was actually notified by Mr. Canfield.
On July 1st?
I don't recall the specific data, but it was following his inspection, and he just was providing updates on his observations.
And what did he tell you?
He expressed, what he observed. He had the impression that the partially buried vessel was being removed and required a Form 27, and that he did observe contamination under the vessel.
And do you agree that there was free product on soil or groundwater on July 1st, 2019?
I didn't actually see it.
Who did see it?
I believe Mr. Canfield did.
And nobody else from KPK saw it? None of the crew?
I don't know.
Do you dispute that there was free product or on soil or groundwater on that day?
No, it's within the area of known contamination, the historical contamination, so it's not surprising that that would be observed.
Do you know that that is a per se exceedance of Table 910-1 standards?
Yes, but it was already identified and communicated.
And how's that? When was that spill identified and communicated?
Through the March 15th supplemental Form 27 that included the Phase 2 report of the area.
It included excavating around the produced water vessel and identifying it there?
No, but it identified the locations of no contamination and delineated where contamination was known to be.
And I may have misunderstood you. When did you say the Form 19 was ultimately filed?
I believe it was filed July 10th.
And so Exhibit 311 that shows it was filed on October 4th, is that incorrect?
I have to double check. I do believe there was a Form 19 filed in July.
Did you provide that in this hearing?
I don't know if it was provided.
Do you think it would be important to provide that sort of documentation?
Yeah.
And do you think that reporting a spill definitively means that KPK caused the spill?
No.
Do you believe that staff must request that you file a Form 19 prior to filing one?
No.
Who owned the Grant Tank battery or operated it? Who was the operator of record of the Grant Tank battery prior to KPK?
I don't know.
Oh, you don't know?
No.
How many supplemental Form 27s has KPK filed in the Grant Tank battery since that November 2018?
There's been a fair amount. We provide quarterly updates to staff.
And a Form 27?
Yes.
And any others?
Any other Form 27s?
Right.
Yeah, they're provided on a quarterly basis.
And any others in addition to the quarterly basis ones?
Yes.
And when would you file those?
I mean, this is through conversation with staff, but you know, they've provided guidance on if, you know, to do any, you know, investigation work, you know, to submit those kind of plans, have them review and provide comments and approval prior to commencing.
And did I understand you correctly? Do you believe that the November 2018 Form 27 covered activity that occurred in July 2019?
Yeah, because nothing happened in July 2019. It was already is all associated with what was identified in the complaint from the landowner.
So you think anything related to that complaint, you don't need to file a new Form 27, it's in that 2018 one?
No, if something new had happened, but nothing did.
So you knew about that spill prior to July 1st, 2019?
Yes, again, in the March 15th supplemental Form 27, the Phase 2 assessment report identified that contamination.
Okay. Does a satisfactory integrity test mean to you that KPK does not need to report a newly discovered spill?
No, but this was not a newly discovered spill.
Do you know that Loveland is over 25 miles away from Firestone?
Yes.
And when you were reviewing the weather chart with Mr. Jacobs, did you notice that the high precipitation mark before it went down was 0.07 inches?
No, I just noted that it was an increase in precipitation.
Okay, but there was no context for what that level actually was.
No.
And did you assist in helping prepare for this hearing with regard to collecting documents that were relevant?
Yes.
Do you know if KPK provided any information related to Mr. Peterson's alleged 811 call on July 1st?
I don't know if that was provided.
Do you think that would be something important to provide?
If staff thinks it's important.
One moment. No further questions. Thank you.
Redirect, Mr. Jacobs.
Mr. Chairman, thank you. I have no questions for this witness on redirect.
Questions from commissioners? I saw Commissioner Nanjapa first, followed by Commissioner McGowan.
Thank you, Mr. Chair. Thank you, Mr. Noav. I appreciate your testimony today. I wanted to just get a few things straight on the timeline here. So upon that July 1st, 2019 inspection, where Mr. Canfield encountered KPK personnel, Were you among the people that he spoke to that day?
I don't know if he spoke to me that day. I wasn't on site. He did communicate with me following that inspection, but I don't know if it was July 1st.
So there was indication of a couple of phone calls. Apparently the first person didn't know. He was asking the personnel whether there was a Form 27 filed, and they didn't know. So he called someone. The first person didn't know. So then he called somebody else who then had a conversation with him. Was that you?
It very well could have been. We did discuss the Form 27, if it was in place or been filed.
You did discuss that?
Yes.
Okay. And my understanding from the inspection report was that there was some confusion as to whether the rule that he was noting, 905, was had been in place, and whether that governed the removal of a partially buried tank.
Yeah.
Is that your recollection?
I do recall. I recall the discussion of trying to communicate that we had no intention of removing it. We were simply resetting and repairing.
And so you had that conversation on July 1st that it was not a removal?
I'm not positive of the date, but I do know that conversation was had with Mr. Canfield.
Okay. I also note that in the conditions of approval on that form, the inspection report, on July 1st, that it does say a submission of Form 19 was requested. Did you understand that?
Yes. Now, for I guess additional context on that, there was more information passed along that phone call with Mr. Canfield, because I don't believe that inspection report was actually submitted until a significant time later following his inspection. So that information documented in the inspection report wouldn't have been communicated to us until it would be on that inspection report. I don't remember when it was actually submitted, but August, September.
And to your knowledge, did you have a conversation? Did he mention the Form 19 in your conversation?
Yeah, he did. He did note his observance of contamination on the partially buried vessel, and in that discussion, again, it was communicated that we are aware of that contamination, which has already been communicated. It's within the known area of the historical contamination that was delineated by Apex Consultant for our Phase 2 assessment.
And did he note that there were requirements for reporting this as well?
He did, but his basis for reporting it was that it was a new release, newly discovered, whether it's historical or not. This was not newly discovered. It was not a new release. It was all, again, communicated months prior in supplemental Form 27 submittals.
Okay, and were you aware that the discovery of any spill is to be reported?
It's not of any spill. I mean, there are applicable, applicability determinations of a spill, but
would this have met those applicability determinations?
Yes, but we were already under an approved remediation plan to address this known historical contamination, and then we're moving forward with that remediation plan.
So do I understand correctly that the spill that was previously reported that was some distance away from this tank battery is all connected under the surface?
Yeah, it's at the tank battery. In our Phase 2 assessment, we identified the known area of contamination. It's not fully delineated, but we do identify areas of known contamination, and it's within the footprint of this location. The initial communication wasn't for a separate location, a separate spill. It is this Grant tank battery location that we are still addressing.
Okay, thank you.
Commissioner McGowan.
Thank you, Mr. Chair. Thank you, Mr. Knott, for your testimony today. and I apologize, I am just really struggling with the timelines and what came first, the chicken or the egg. So when you all realized that there was some sort of contamination and you hired Apex to do a report, and then you did soil samples and you discovered that, yes, there was some sort of contamination, how do you, so you have that report, KPK has owned the site since 1994?
That's correct.
Okay, so how do you know that, so 27 years is a long time, how do you know that that contamination was pre-KPK ownership or during the 27 years that KPK has been running the site? Since you haven't identified where the spill has come from exactly, the source, or how do you know?
Correct. It was on the basis that we had no reportable releases. We had no remediation projects associated with the location since our ownership.
So you also don't know that perhaps this historic spill or leaking or whatever, it might have happened since 1994.
It might have, but based on what we know about the operation of the facility and what the absence of anything been reported in terms of spills or cleanups, we didn't believe it was associated with our operation of the facility.
Okay, so but thank you. So you did think, though, however it had happened or however long ago, it's somehow associated with the tank battery.
Yeah, and
the location of the tank battery.
And that's kind of what that forensic analysis showed us was, type of oil that is produced at that battery matches, what the contamination was subsurface.
Okay, so when you found out from Mr. Peterson, and maybe you didn't, so maybe here's a disconnect. If Mr. Peterson, did he tell you before he was going to go out and try to remediate, or did he not tell you that he was going to go out and try to address this tilted tank battery?
No, he didn't tell me because this wasn't a remediation activity. It was just a repair maintenance activity, which I don't manage. That's the Rouse Department. They were strictly there to perform maintenance on that tank.
So did Mr. Peterson know that you guys, you guys, it's a very Midwestern thing, I apologize, that you all knew that that you were trying to address some sort of historic spill at the same location? Was he aware of that other work that was occurring?
Yeah, he was aware that it was an active remediation location.
So for me, if I was working for you and I knew that you were already investigating or looking at an historic spill, and it somehow was around the tank battery, and then I saw that it perhaps had been lifted or changed in some way, I might want to have a conversation with my environmental compliance director of do you think these things are related? Do you think we should have a conversation with COGCC, or do you think we have concerns about this? So I'm trying to figure out why there might be that disconnect there, and not some sort of kind of a little flag that would go up and say, this is all that same location and we're kind of dealing with something that we're not sure of. Should there be a conversation? So you don't think that was unusual, that there wouldn't be some connection made or a conversation?
Not in this specific instance. I think Mr. Peterson was aware that the identified subsurface impacts were substantial. They encompassed a large portion of the location. So I don't think it was surprising to him when they did the excavation for the vessel repair to observe contamination, because it was already within the known area of contamination. So that wouldn't have raised a red flag. See, at some point in the remediation process, we would be at that spot of the tank battery to under the produced water vessel to remediate that soil.
Okay. Okay. So now we're to today, and that tank is sitting outside. It has not been put back in place, which is what you all say that you want to do. And so again, I'm going to use the analogy of fixing my bathroom again. I'm not sure that I would want to put a piece of equipment from the bathroom that's 27 years old back into my bathroom. So is it, even though you did an integrity test on that tank, would it be normal to put back a 27-year-old piece of, well, at least 27-year-old. That's how long you guys have owned it. I haven't heard that it's a new tank battery, that you guys put in a new tank battery. So I'm assuming that it's 27 years old. Would it be normal to put in back a piece of equipment that's old, or would you normally replace it with something updated?
The equipment's not that old. That's been upgraded since our ownership of the facility. We would have to re-review the integrity of the tank, even though it passed the test that we performed in February of 2019. And we'd also probably need to communicate that, right, with staff, just because in the approved Form 27, you know, it says that we will put a new tank in there. So I think if we wanted to change that plan and put the existing tank back into service, we would need to submit that to them and have them review. And you know, I'm sure they would have comments, you know, want that integrity test reperformed, or maybe not even allow it. But it's still on location because, again, it was never intended to be removed from location with the repair work. It was never intended to be taken out of service. It was just being repaired.
Okay, so we're 2 years later now, and I'm wondering why it's not back in the ground and repaired and put back in place.
We are excavating the impacted area, and our excavation is encroaching on where that would normally be set for normal operations. In addition, we cannot operate this facility until the remediation of the soil impacts is complete. So there's no benefit to put it back into place or in service.
I see. So you all are still trying to discover. So sorry. You're still trying to finish remediating the contaminated soil, source unknown.
Correct.
The historic. Okay. Okay. Thank you. Thank you very much.
I see Commissioner Njaba and Commissioner Messer's hand up. I've got a question that I think ties into Commissioner McGowan's line of questioning. With regard to the existing Form 27, right, and all the Form 27 supplementals that were a part of this whole remediation package for this historic contamination, is the excavation or the activity of excavating at that site in itself a trigger for an additional Form 27 supplemental if it hadn't been contemplated as part of the remediation work to begin with?
Yeah, I believe that information hadn't been provided, right? If that wasn't part of our initial remediation plan to perform any excavation activities, that'd be unique. Most of our remediation plans involve excavation, but if that was absent in any kind of Form 27, staff would definitely want to have that communication about, you know, the new plan is to do excavation activities.
Okay, so I mean, I guess as far as you know, was that excavation around the tank associated with or contemplated in a previously submitted Form 27?
No, only because that excavation around the tank was specific to repairing the tank and resetting it.
And I think what I'm getting at is that if you're excavating on a site that's got some historic contamination of which you do not know the extent of, then there seems to me there would be a potential that that contamination may be around that tank, and any excavation could be a part of that site and potential historic contamination, even if it's not a directly remediation activity. And I'm just trying to understand, is that activity on its own a trigger for the need for a Form 27?
I don't believe so, because it doesn't change the remediation plan. The remediation activities that were communicated to address known impacts.
Okay, what about the point where you discovered, or when it was brought to your attention, should I say, that so Mr. Peterson identifies that this tank is listing. He goes out there, they start digging, they discover, perhaps with the help or notification of a field inspector, Mr. Canfield, that there was contamination there. At that point, you're linking that contamination to the historic contamination, and additional remediation work is necessary. Wouldn't that be a trigger for the Form 27 at that point, or Form 27
Yes.
supplemental?
And that was the basis for the July 2nd, 2019 Form 27.
Okay.
Right? We acknowledge that there is contamination. What you observe is contamination. But it's already within an area that we know is contaminated. And our previously approved remediation plan to address that contamination is still in place, and we plan to approach it the same way.
Okay. And then I want to think through this next question. What is the tank battery, the tank as it currently sits, the produced water vessel outside the excavation site, as it currently sits, is it closed?
How that tank is constructed, it's not like an isolated or a vessel that can be isolated. There are openings and unsecure closure or lids.
Yeah, I don't know that I'm getting at the actual like physical, was it closed? I'm trying to understand in the context of Rule 905B, that tank battery, what in your mind, and I'll ask you because you're the witness, what in your mind constitutes a closure of a tank battery?
Oh, like a location closure or a partially buried vessel?
A partially buried vessel as described in, was contemplated in Rule 905B.
So in that, this is a little different because, typically the request for closure of a partially buried vessels, it's on remediation project and doesn't usually overlap with a remediation, in-place remediation project, like of this scale. But typically you identify the vessel, location, sample, confirmation sample locations, to show that there is no contamination associated with the vessel's operation. And then for closure, you want to submit, the results of those samples, the sample locations where the samples were collected, and provide that, with a closure request to notify staff that, that vessel is no longer in use.
And a vessel that's no longer in use, can it come back into use? Can you reopen, should I say, a tank battery or a produced water vessel at location?
I would assume so. I don't think it would be identified as the same facility or piece of equipment, right? It'd be a new piece of equipment that was set, and based on how it was installed, if it was subsurface, if it's identified as a partially buried vessel, then I don't think there's any issue doing that.
Okay. Thank you for that. I'm going to pivot real quick to the Form 19, and I guess the question I have is, when we know what the Rule Form 19 triggers are for the rule and what triggers it being reportable, can a spill that was not previously identified as being reportable subsequently be identified as being reportable?
Yes.
Okay. And was that the case in this, at this location, where subsequent to all the remediation work going on with the identification of the historic contamination, now you're digging up the tank, the produced water vessel for a different purpose, but you discover the contamination of groundwater there. At that point, does it become reportable?
For this instance, I don't believe so, because it was already known that we already knew about that contamination. It was already reported with the Form 27, and we were already under an approved remediation plan to address that contamination.
And I do recall that, and that is correct. And I think I recall that there was identified groundwater contamination at the time that the Phase 2 assessment was being conducted. Is that your understanding as well?
Oh yeah, it was identified both groundwater and soil contamination were present.
So I mean, even though staff didn't require you to do a Form 19 at the time that your Phase 2 analysis suggests that groundwater was contaminated, and groundwater is considered a water of the state, wouldn't that be the trigger for a Form 19 and making the spill reportable at that time?
There's that possibility, but I believe because we were operating under an approved remediation plan, we were continuing operations with the assumption that the state was aware of it, staff was aware of it, and then because there was no additional COAs with the approved remediation plan, that we continue under that plan.
Thank you, Mr. Knopp. I saw Commissioner Nanjapa's hand up and Commissioner Messner's hand up. I don't know which one I saw first, so I will go back to Commissioner Nanjapa first.
Thank you, Mr. Chair. Thank you, Mr. Knopp. I just want to kind of go back a little bit also to the line of questioning that Commissioner McGowan had with respect to the process for when really any operation is going to be undertaken. So Mr. Peterson observes the tank listing. He can just on his own go out and make a correction, or does he need to notify someone?
No, I believe it's within his role that he can make that determination and implement those field operations to address those type of concerns.
So he indicated he contacted his supervisor. Because he did that, is it typical? Do you have kind of a standard operating procedure where, you know, if a supervisor is contacted by somebody out in the field that they need to then, and it relates to an area that is known to be undergoing and ongoing remediation or near, you know, what is your SOP for that kind of thing? So the fact that just the simple fact that it was this location that was near a known contamination site. Should he have, it sounds like at least his testimony was that he called his supervisor. Then what is that next step?
Yeah, and I'm not aware of why he called the supervisor, what that was in reference to, if it was for the repair work or just discussion about what he observed. You know, this is a unique situation where, you know, doing repair and maintenance work within an area of known contamination, you know, there's not really an SOP really. This is such a unique situation where, there's no language that we, or we say continue with repair work because the area you're working in is within a known area of contamination. That's kind of a unique scenario. So for this one, that would, default to their discretion, the supervisor's discretion on how to proceed with the field operations and the needed repair work.
Okay, thank you.
Commissioner Messner.
Thank you, Mr. Chair. I've got a few questions and they're going to be a little bit all over the place, so I apologize in advance for that. But again, I'm just trying to make it clear in my notes at this stage that I understand what you're testifying to and kind of a timeline of events. And so I think the first question I have, and this came from Commissioner McGowan's questions, and your response, Mr. Knopp, is that this was not an original produced water tank. This was one that was acquired by KPK. Is that correct?
I believe so, based on the type of tank it was. It was a fiberglass tank, smaller volume. Seems that it would be something we install as an upgrade to a facility.
Okay. Do you have any idea when that could be?
I do not.
Certainly within the ownership timeline that KPK was under ownership of this particular site, correct?
I would estimate that. Again, I'm just assuming it's a typical type of a piece of equipment that I think would be upgraded at a facility from this age, but I'm not positive of when it was done or if it was even done.
So if this was done as you had previously indicated, I'm assuming that when this was installed, seeing how it was a partially buried produced water tank, that there would have been similar style of excavation to what we saw, within this situation when it was installed, 6 foot deep excavation in order to be able to access the bottom of it, to be able to connect the different lines. And is that fair to say?
Yeah, when and whoever installed it, yeah, would have been similar.
Okay. And to your knowledge, was there any documentation provided or any record that there was a spill that had occurred or hydrocarbons in the soil or water at the time that this was installed?
I don't know of any records.
Okay. I think this is an important point. So I think it might be good. I'm going to go back into COGCC records and see if there was any indication of a spill at that time. The other question that I have, I mean, so I guess I'm just trying to understand kind of like Commissioner Nanjapa was talking about standard operating procedures and, you know, understanding. I think we've had, you know, a number of comments, you know, through this process indicating that forms in many ways are communication between an operator and the COGCC. And in particularly in situations where we've got spills and remediation, that communication is incredibly important as far as ultimately the protection of public health, safety, welfare, the environment, wildlife resources. I mean, I'm assuming that you, as the environmental compliance director, understand that there's some sensitive receptors in this particular area, and that the testing you've done up to this point, or had been done up to this point, not only by you, has indicated there already is some impact to these receptors. Is that correct?
That's correct.
And do you feel like it is important as part of the remediation and communication of whether it was a current or historic spill to initiate that communication with the COGCC through forms, that if you were excavating around this produced water tank and encountered hydrocarbons that could potentially impact groundwater, that would be important information to communicate to ensure that these receptors don't continue to get impacted?
Yeah, it's important. That's why we didn't provide communication multiple times about it.
So did you provide communication, or were you asked to provide communication in this particular situation?
Well, we were essentially asked to as a result of the complaint, but through our own phase 2 assessment, we identified areas of contamination, which was communicated.
But when you were doing this excavation, did you file a Form 27 or continue that communication once that hydrocarbon was found underneath the produced water tank excavation?
Yes, again, in the July 2nd, 2019 supplemental Form 27, information specific to that excavation and its correlation to the historical contamination was communicated.
But not until it was asked to be communicated by COGCC staff after an inspection, is that right?
I mean, it was one day after its inspection, but yes.
Were you informed by the Rostabout crew that they encountered, you know, hydrocarbon stained soil and, you know, underneath that particular excavation?
I was informed by Mr. Peterson of what the events had happened from the inspection.
After the inspection, but not prior to?
No.
Okay. In your experience, you know, is it possible that there could be a historic spill and a current spill on the same site?
It's possible, but I don't believe it happened here.
Okay. And why do you not feel like it happened? Why do you feel like it didn't happen here?
It goes back to the integrity test of the produced water vessel. The observed contamination under the produced water vessel, you know, that would have been the source for a new release, and the integrity test showed that vessel had integrity and was not releasing any product.
Okay. I think I had another question, but I can't find it in my notes right now, so I will, I'll be good for now. Thank you. Appreciate the responses.
Thank you.
Thank you, Commissioner Messner. Commissioner Nanjapa.
Thank you, Mr. Chair. Just one more quick question for you, Mr. Knopp, and then I have one for AG Rosenberg, or Mr. Rosenberg. How far approximately, so you had mentioned about how the testing revealed that the hydrocarbons present matched with the crude oil that you were producing. How far away is this battery from the actual source of production?
So the partially buried vessel is actually located at the tank battery location. Now it's how it's produced from the wells to the location separator. It's an emulsion, so that's where it's separated out into produced water, oil, and so you get this specific vessel is just taking the produced water product of the well's production. So where the oil would go to the oil tanks.
So the well though is approximately how far from where this tank was sitting?
I believe there's 4 associated wells, and they're all at least, I want to say at least a quarter mile or so, in different directions from the battery.
Okay, a quarter mile or so. And are there flow lines near these as well, near the tank as well, the buried vessel?
Well, yes, for the associated wells, those flow lines, converge to the separator.
And I'm assuming that as part of his initial spill, you've been, and as you're trying to determine where the source is, you've been testing the integrity of all of those.
Yeah, we did flow line pressure tests prior to, or while the wells were shut in, and it would, following the complaint, to show the integrity of the flow lines.
Okay, thank you.
Mm-hmm.
And then, Mr. Chair, I have a question from Ms. Rosenberg.
Go ahead.
Thank you. First of all, I just wanted to make sure that I was understanding. I know we have AAG staffer, but I should know this, but are you also an AAG?
No, although I did represent the commission from 2007 to 2009 at the AG's office, but I'm in-house staff, an enforcement officer at the commission.
Thank you. I wanted to be sure that I was titling you correctly. So one thing I wanted to, I noted, as I mentioned in my questions to Mr. Knopp, that the inspection report did request a Form 19. However, as Mr. Knopp noted, it was not submitted until September. The reason for that?
The inspection report, why it wasn't, I don't know. Are you talking about a lag between the inspection being completed and the report being issued?
Yes.
That would be a question for Mr. Canfield. I don't know the answer to that.
Okay. And then sorry, one more question, which may be also appropriate for Mr. Canfield. I noted that there was in the NOAV, it refers to a June 21st date. And I think that also is repeated in a letter to Ms. Gillette. Was that just a type of clerical error?
That was a clerical error, and that is one of the reasons that we included in the stipulated facts that these events occurred July 1st.
Okay, I just wanted to confirm that. Thank you.
Mm-hmm.
Commissioner Messner.
Thank you, Mr. Chair. And I did find my other question. I apologize, Mr. Knopp. I'm not sure I understood in previous testimony why the decision was to finally remove this produced water tank. Do you know the answer to that?
Yeah, it was ultimately through conversations with staff and knowing that, one, the facility's already shut in. This vessel's not in operation anymore and won't be until we complete this remediation. We are going to have to excavate this area where it was originally set. We can go ahead and move forward, even though we disagree with the assessment that it was being removed on July 1st.
So it was just to get it out of the way.
Yes.
Okay. That's good because it was unclear in my notes. So thank you.
Thank you, Commissioner Messner. Mr. Knopp, following up on that, when when was the activity to remove the vessel commenced?
I'm not sure. I know the Form 27, requesting approval for its closure was in October 2019, but I do know when crews were directed to stop operations, that vessel just kind of left as is in place for a time period. And I don't know between July and October when the official time was when it was physically pulled out of its location and set out of the way.
Okay, thank you.
Mm-hmm.
Are there further questions from commissioners? Commissioner Nanjapa.
Mr. Chair, if it's appropriate at this time, I would like to recall Mr. Canfield and just ask him a couple of questions, or is it more appropriate at a?
Let's get through KPK's case in chief, and then before we close this NOAV, we'll recall any witnesses we need to.
Okay, thank you.
Mr. Jacobs, I think now's your opportunity for a brief redirect following commissioner questions.
Yes, very briefly. Mr. Knopp, I just wanted to clarify, you mentioned that there was a lag time between the inspection date and the submission of the inspection. You recall that testimony?
Yeah, I do recall saying that.
And I'm sharing the inspection report. You see here upper right by my cursor, the inspection date and the submitted date?
Yes, I see it.
And that's September 6, 2019. This was submitted by Mr. Canfield. Is that correct?
That's correct.
And I believe you also got a question regarding the filing of your Form 20, Supplemental Form 27, the day after the inspection, July 2nd.
Yes.
Was that purely because Mr. Canfield told you to submit a form, or was it also because you were aware that contamination had been encountered at the site where prior Forms 27 had been submitted for remediation of contamination?
No, yeah, it also incorporated quarterly updates that we've committed to provide progress updates and results from sampling activities.
So your dispute until forms were submitted in October was purely whether a new Form 19 and associated Form 27 was required for this known historic contamination?
Correct.
I have nothing further.
Thank you, Mr. Jacobs.
I ask a few questions and follow up to that?
Very briefly, Ms. Rosenberg.
Sure. Mr. Knopp, did you know about the July 1st inspection prior to September?
Yeah, I had communications with Mr. Canfield.
And then when KPK replaced the old concrete produced water vessel, did you file a Form 27 for that?
I believe that concrete vessel is still in place. I don't know. There is one at the location, so I'm not familiar or sure if which one you're referring to, if there are multiple or.
I understood you to say that you replaced the produced water vessel in question is a newer KPK vessel. Is that correct?
I'm going to object. I think the prior testimony, it's clear that he didn't know if it was replaced at all, but it was a certain vintage where it might have been a newer upgrade.
Yeah, I think that's fair, Mr. Jacobs.
Okay, thank you. I hadn't understood, so I was trying to get clarity. Thank you. No further questions.
Thank you, Ms. Rosenberg. Mr. Jacobs, I think we can let Mr. Knopp go for now and call your next witness.
Very good. Thank you, Mr. Knopp. Mr. Chairman, with your permission, respondent calls Mike Haddle. He'll give us a moment to get him situated in the witness room. Haddle, you can hear me okay?
Yes.
We can hear you. Thank you. I'll proceed now, Mr. Chairman. Good afternoon, Mr. Haddle. Would you please state your name and current employment again?
Yeah, Mike Haddle, owner and operator of Apex Consulting Services, Inc.
Thank you. And I believe you've previously testified you've been providing consulting services for KP Kaufman for 15 years. Is that correct?
That is correct.
And you have over 30 years experience in environmental consulting?
That is correct.
You were engaged by KPK in early 2019 to conduct a subsurface investigation at the Grant Tank Battery location. Is that also correct?
Yes, it is.
Who contacted you about performing that work?
Susanna Laura Mesa.
And is Ms. Laura Mesa the former Vice President of Engineering of KPK?
Yes.
Did Ms. Laura Mesa explain to you what prompted her request for your subsurface investigation?
Yes, she indicated that the owner of the property had engaged with a third party to investigate soil and groundwater conditions in and around the tank battery and across other areas of the property. And I was provided with the report.
And I'm going to share a screen real quick. Is this, coming up now, is this that report of October 12, 2018 by CPL Thompson, what you were provided?
Yes.
Thank you. And did you review and consider the data in the CTL Thompson report in the planning for and conduct of your subsurface investigation?
Yes, I did.
And did that work involve using your geoprobe equipment that to obtain soil and groundwater samples at the site that you had shown us with photographs related to a prior NOAV in this hearing?
That is correct.
And did your work result in laboratory analysis of the samples obtained through use of your geoprobe equipment?
Yes, it did.
And is the results of your work and the laboratory analysis documented in a report?
Yes, yes, they are.
And let's see here. Great. I'm gonna share screen again. Bear with me. Is this your March 14 report provided to KPK at the request of Ms. Laura Mesa?
Yes, it is.
And is the work you did at Grant Tank Battery depicted? I'm scrolling down, as you can see, to some of the figures here. Rotate this thing. There we go. Excuse me. I'm showing figure 2 of your report, which is KPK Exhibit K. Can you see that figure 2?
Yes, I can.
So is your work graphically depicted in this figure, the geoprobe work, and can you explain it as it is shown on this figure?
Yes, the figure illustrates my boring locations. I installed borings MW1 through MW5, and they were completed as groundwater monitoring wells. And TH-11, which is in the center of the left side of the figure, was actually installed during the work performed by CTL Thompson. And then I also installed 3 just plain probe borings across the property, PB1, PB2, and PB3, and PB4.
Thank you. And is this, by my cursor there, just below MW4 and PB1, is that the original location of the partially buried vessel that contained produced water?
That is correct.
But this yellow rectangle is really the entire tank battery facility, is it not?
Yes.
I think there was a little confusion on that earlier. I want to clarify that. And did the work you did at Grant Tank Battery also yield sample material used by Mr. Noav to obtain a forensic soil analysis from the Dolan Integration Group?
Yes, I believe Mr. Knopp utilized some of the soil samples that were collected and sent them off to Dolan.
Has any other work been performed by you regarding the subsurface conditions at the Grant Tank Battery location?
Yes, since those monitoring wells were installed, I have been collecting groundwater samples from those wells, a surface water sample from Godding Hollow, and I have also installed a additional well, which would be MW6, which is located to the north of MW4 and north of Godding Hollow Parkway.
Great. And I believe you're referring to Godding Hollow. Is that the unnamed creek that has been referred to previously?
Yes.
So it does have a name.
Yes.
Okay. And I believe Commissioner Nonjapa asked someone earlier about the slope down to the stream. You've been down there quite a bit because you take surface water samples when you do groundwater sampling. Is that correct?
That is correct.
Can you describe the drop from the grade at the tank battery location down to the surface water at Godding Hollow?
From the western portion of the tank battery that was illustrated with the yellow box down to the surface water of Godding Hollow is approximately 10 to 11 feet.
Okay. Now, I believe we reviewed earlier in the prior NOAV that you have a bachelor's degree in geology and a master's in engineering geology. Is that correct?
That is correct.
And in the first 3 years of your professional employment following either undergrad or your master's, you worked for the USGS in their
yes, I worked for the U.S. Geological Service in the water division.
So you have expertise regarding hydrology, geology related to groundwater and its interaction with man-made structures?
Yes.
You have an understanding of what might cause a partially buried vessel to float up or pop up out of the ground?
Yes, if that vessel is not full of whatever material that it is intended to store and is empty, surface water and or groundwater can cause that vessel to float or rise.
And you heard prior testimony that this vessel had been mostly emptied, all but I think 1 foot and 6 inches of produced water since the prior May.
Yes, I think if I recall correctly, as of May 3rd, I believe, the vessel was void of fluids with about 1 foot 6 inches remaining.
In your experience and based on your education and expertise in groundwater and hydrology, does a partially buried vessel like this only pop up in fairly immediate response to a discrete weather event like a flood or a storm, or might it happen over time?
It can happen over time. Obviously, if you have a large enough storm or event, it can be an immediate floating, but it can happen over time over a series of events.
Okay, thank you. And you said you performed surface water sampling each quarterly sampling event, is that correct?
That is correct.
Have you ever detected any impacts from the historic contamination at Grant Tank Battery and the surface water of Godding Hollow?
No, there have been no detections to date.
Thank you very much. I have no further questions for Mr. Hattel at this time.
Thank you, Mr. Jacobs. Ms. Rosenberg?
Thank you. I have just a few questions for you. You confirmed Mr. Jacobs's restatement of prior testimony regarding the produced water vessel a moment ago. But did you see the vessel on July 1st, 2019?
No.
And the phase 2 assessment, did it definitively determine the source of the release?
It determined that there had been a historical release at the property.
Right, but specifically, where did that release originate? Did it determine that?
No.
Do you see a distinction between the discovery of a spill release point and the discovery of contamination?
Can you clarify your question?
Is discovering contamination per se identical to discovering a spill release point?
It can be, but it depends on when that investigation was performed, and
They can be two different things.
Yes.
And can a battery have multiple failures of release mechanisms? Meaning, could there be more than a single source of contamination in a battery?
I would imagine.
Thank you. And no further questions. Thank you.
Redirect?
No redirect at this time. Thank you, Mr. Chairman.
Questions from commissioners? Commissioner Nanjapa.
Thank you, Mr. Chair. And thank you very much, Mr. Haddle. Appreciate your testimony. Just a couple of questions for clarification. Did you say that you installed the MW wells?
Yes, ma'am.
And so we have some of the analytical reports in Exhibit K from KPK. So are those your samples that you took and then sent to the lab? Is that correct?
That is correct.
Okay.
I believe it is. I haven't seen Exhibit K. If you'd like to show that to me, I can just definitely say yes or no.
I would look to Mr. Jacobs if you want to show.
If it please the commission, I'm happy to pull up again and share screen Exhibit K.
Please do.
Phase 2 report of Apex Consulting Services. If you'll direct me to where you want to be in the report, Commissioner Nanjapa, I'm happy to go there.
I believe it was table 2.
Okay.
Can you see that?
Yes, I can.
And I was just trying to, and also from the, looks like it was MW4, if I am looking at this correctly, in table 2 that did have some exceedances.
That is correct.
And where's the location of MW4? I was just looking at the...
It's immediately adjacent to and just north of the vessel in question.
I just pulled to figure 2 there.
Thank you. And do we, I was trying to see where the results from the surface water samples are shown.
It's also in that table.
It's in that table?
It's in table 2, yes.
Okay. Which one does that correspond to?
GH.
Oh, that's the GH. Okay.
Yes, ma'am.
Okay, thank you. I just wanted that clarification.
Sure.
Other questions from commissioners? Seeing none. Mr. Jacobs, did you have any additional redirect following Commissioner Nanjapa's question?
No, thank you, Mr. Chairman. We have no further questions for Mr. Haddle.
In that case, I believe we can let Mr. Haddle go, and you're welcome to call your next witness.
Thank you.
Give us a moment. Respondent will be calling Mr. John Peterson. As soon as he's situated, we can get started with your permission.
It looks like he is seated, and if he is ready, we are ready.
Ready. Mr. Peterson, welcome back to the second phase of the hearing. For the sake of efficiency, may I confirm that you previously testified about your education, work experience, and professional licensing leading up to your current employment with WSP USA as Senior Vice President, responsible for the Southwest Mountain Division, and that remains unchanged as of today?
Yes.
Thank you. You were engaged on KPK's behalf to evaluate evidence of historic contamination at the Grant Tank Battery location. Is that correct?
Yes.
And what information did you review to perform that evaluation?
I reviewed the CTL Thompson Phase 2 report, the Apex Company's Phase 2 report, several of the Form 27s associated with this site, the progress summary on remediation that's prepared by KP Kaufman, and conversations with Mike Haddle about site-specific conditions.
Did you also review a report by Dolan Integration Group?
Yes, I did.
Very good. And are those the KPK exhibits J, K, and N that were previously displayed during this NOAV hearing through KPK witnesses?
Yes.
And what did you learn about the subsurface conditions at the location based on your review of those reports? And you could take them one at a time.
Sure. Maybe I'll go first by talking about the site geology, the groundwater conditions, and then the contaminant fate and transport that I can see from that data.
Sure.
In the CTL Thompson report, there's just one boring on the west side of the property. I think it's TH11 that has contamination in it. It's on the down gradient side of the site. So that's the only information from that report. But essentially, if you look at, maybe we could bring up a site photograph, and I could describe what I know about the site based off the site investigation. Maybe the
Sure. Figure 2 from Mr.
From
Apex report.
The Apex report, that would work.
Okay, can you see that?
Yes, so you can see TH11 there. That was done prior to all these borings. The monitoring wells 1, 2, 3, 4, and 5. Those are all monitoring wells into the groundwater table. Borings 4, 3, 2, and 1 did not have monitoring wells installed. The site geology there, we've got clay soils, top 6 or 7 feet or so, and a sandy clay, also a clay material with a little more sand content, down to at least 15 feet based on the site borings. The groundwater flow direction is going from right to left, west, northwest, from MW1 towards MW4 or up in that northwest direction.
Yeah.
Yep.
You want me to show figure 4 from this?
Sure, you can show that quickly. Yeah, those groundwater contours show elevations and lines of equal potentiometric surface along that groundwater table. The gradient there, which is basically the distance of drop per distance of horizontal movement, is about 0.009 feet per foot. So every foot we go out, the elevation drops 9 thousandths of a foot. So it's very flat, which is typical in this area, typical in clay soils also to have a very flat gradient. Those are the geologic conditions and the groundwater conditions, which means that contaminants from a site like this, once they travel vertically into the groundwater table about 7 feet down, will start migrating to the west, northwest with the groundwater flow direction, absent any other man-made obstructions to the groundwater flow. What else? The soil type, I just did a rough calculation, Darcy groundwater velocity for clay soil type with 10 to the minus 6 centimeters per second permeability, 0.009 gradient, porosity of about 20%, and you can easily get to about 0.001 feet per day of groundwater velocity. So in a period of a year, 365 days, you can get to about 1/3 of a foot, so 1 foot every 3 years. I don't have site-specific data about running permeabilities and other data to get a really precise number. So if you look at an order of magnitude of 1 foot every 3 years, 10 feet every 3 years, that's still reasonable. 100 feet every 3 years, so 2 orders of magnitude more, that's still pretty reasonable. 1,000 feet every 3 years, starting to get 3 orders of magnitude, probably not, most likely not. So anywhere from 1 foot every 3 years to 100 feet every 3 years. This site's about 300 feet east to west. So it'd take about nine years for the groundwater on one side to make it to the other at that rate. Is that right? My math, 1 foot every 3 years. Sorry, 300. That would take a lot more than 9 years. Take hundreds of years, which
math is not my strong suit, but
yeah, I'm off of orders of magnitude. Take hundreds of years, and we know this facility wasn't here in hundreds of years, but we're definitely talking decades, decades of travel time to get from one side of the site to the other. So that's kind of the groundwater conditions, the contamination that's been found. If you look at, go back to figure 2, you can, and you look in the site data, basically PB4, PB3, PB2, PB1, MW4, MW3, TH11, all of those borings have contamination in them. And when I look at this site, to me, I would assume, given what I know, that there's really one release here. It's all contiguous piece of contamination, with the source being somewhere between PB4 and PB1, since we have a control point up gradient. That's what I see here is one plume of contamination sweeping across the site from right to left, starting somewhere on the east side of PB4, but I don't know where exactly or what would have contributed to that. Obviously there's a tank there, which could be a source, or the building. I don't know what's in the building, but could be a source there, or underground lines that I'm not able to see on here. Could all be sources of contamination that could stretch that distance. And it would take quite a long time for that to occur. We're talking decades of time for that to migrate. I was looking at the data specifically around MW4 and pertains to that partially buried vessel. I don't suspect that the tank is a source area for several reasons. The boring log in MW4, it doesn't show contamination in the very shallow parts of that boring. It only shows it once you get down to the groundwater table. And since this boring is really in close proximity to the tank, you'd expect to see contamination from that ground surface, or where that tank was placed, down to the water table in a continuous stream, like we've seen in some of the other testimony, where you see that contamination running down to the groundwater table. I would expect to see that. The concentrations of the contaminants in MW4 are relatively low for a source area. If we were looking at a source area, we'd have a lot more liquid non-aqueous phase liquids, light non-aqueous phase liquids. Free product is another way to term that. We'd see that a lot stronger there at the source area, and the concentrations both in the soil and the groundwater are not reflective or indicative of free product. So that is another piece of evidence that I would say this tank is not a source of the contamination that's in that boring. The other evidence, which was talked about in the testimonies today, was the tank tightness testing passing. I think that shows another data point to show that that sump itself is not the source of contamination over there on that side of the property. And then the fact that there's contamination up gradient of that sump. We all know water doesn't flow uphill on its own. And so the contamination on that upgradient side had to get there from some other place besides that sump, because it won't travel in that direction. Those are my general observations with the site data.
Very good. And then with respect to the Dolan Integration Group report, which I'm pulling up, can you see that?
Yes, I can see that.
It's KPK Exhibit N. You reviewed the results of their forensic soil and oil analysis in comparison, did you not?
I did.
And did that give you further insight into the conditions of the subsurface and, approximate age and well, let's start with that, approximate age of the contamination?
Sure. I can't give you an approximate age. I don't have a dating tool. This isn't a dating tool, what they've done. But there is some correlations and some matching that you can take from this data, since they took some samples of the oil that's produced at that location and some samples of the oil that's in the soil adjacent to the sump. There is a genetic correlation there, and they conclude that in their report. You can show that they're related, similar. One of the big differences is that the stuff that's in the oil, in the direct oil that they sampled, obviously is fresher, and so the stuff that's in the soil shows heavy weathering. Obviously, it takes time for that weathering to occur, and it has to, travel in the subsurface or away from, the specific source of where that oil is coming from in order to degrade and weather like that. And that data supports that the product that's in MW4 and PB4 were those borings that were taken from for those Dolan integration samples are weathered products with genetic relationship to the oil that's produced at the site that you would store and see in the pipes and the tanks there. But it had to, over time, take some weathering, which is strong evidence for a historic release.
Thank you. So based on your review of these phase 2 reports, the Dolan Integration Group report, and the Forms 27 and supplemental information provided to COGCC, have you formed an opinion regarding the location of a source, if there are more than one source, and how long it would take to spread as far as it has?
It's my opinion that from what the data that I've seen, I don't see multiple sources contributing yet. I don't have enough data to prove that there's multiple sources. It looks to me like one source that's all contiguous across the site. As far as the source itself, I can't identify it exactly, but there's something upgrading a PW4, and it could be the tank that's showing there that could be the source of the release. But it will take quite a long time for a source over there to get over to the sump, talking on the orders of decades for it to travel that distance. And I think the observations from the tank with the sump, the partially buried vessel in that soil there, and the tightness testing, as well as the soil that's around that, that we're not seeing a source being that sump specifically. That it's coming from upgradient of that sump because of the concentrations and the observations of that soil. It's not, there's not free products saturated on the water that was observed there. And while there is some sheen that often happens when you're stirring up the soil, it starts to, particles of the oil that's trapped in those grains of soil can become dislodged and start to migrate onto the water. And so you'll get sheens on the water when you start mixing it up. As opposed to in a free product environment, when you have a source right there, you will see oil and sheens on all the soil. You'll see droplets of oil on the grains. You'll see droplets of oil on the water itself, much more than just a sheen.
So I'm glad you raised that point. You heard prior testimony and questions from staff counsel about the work on the partially buried vessel on July 1st at the time of the inspection. Is that correct?
Yes.
And there were pictures of the soil in the area excavated around the partially buried vessel. And I believe there was a reference, several references to free product. Based on those photographs, do you believe that that actually was free product or just oily sheen as you've described, based on disturbing the historic contamination in the bottom of the excavation?
I would say, based off the analytical data from that boring right there, MW4, I think benzene and soil was like 1.2 parts per million. When you're talking free product at a source area, you know, you're talking 3, 4, 5, 10 parts per million is when you start to see, you know, free product and droplets rather than just a sheen.
Thank you for that clarification. I have no further questions for this witness at this time.
Thank you, Mr. Jacobs. Ms. Rosenberg.
Just a few questions, thank you. Were you at the Grant Tank Battery on July 1st, 2019?
No.
Are you aware that this case is about a reporting violation and not specifically about the source of a release?
Only from what I've heard today.
Did you know that staff requested that KPK file a Form 19 for the release that was observed on July 1st, 2019?
I am not aware.
Thank you. No further questions.
Yeah.
Any redirect?
No, thank you, Mr. Chairman.
Questions from commissioners? Commissioner McGowan.
Thank you, Mr. Chair. Thank you for your testimony today. A lot of complicated stuff put into, hopefully, I think I'm understanding a succinct manner, so I appreciate that. So I'm trying to understand if we say decades, we think it might be decades from point A to point B. Is 27 years within the time frame it might migrate?
It could, yeah. That's 27 years would be in my ballpark. Yeah, but I couldn't tell you for sure.
Thank you.
Commissioner Mesner.
Thank you, Mr. Chair. I mean, Commissioner McGowan asked my question, but I just wanted to make sure that I understand how, like, what's the range that it could migrate per year? Because I got confused with the math there for a second because I think everyone was confused. But I think you had indicated that, you know, it's 1 foot every 3 years. Is that what you were saying? Or potentially up to 100 foot every 3 years at the, if those were the two extremes, right?
Yeah.
So potentially it's, I mean, in the middle there somewhere.
Hard to tell without doing some site specific analysis. Every site's different, but there's
no, and I appreciate that. But I mean, I think I'm just trying to figure out, you know, how fast this stuff moves from this through this stuff. So, you know, if we're looking at a range of things between 100 and 1 per 3 years, I understand that. Then that helps me understand how fast this could potentially move. So thank you for that.
Okay.
Thank you, Commissioner Messner. Any other questions from commissioners? Commissioner Nanjapa.
Thank you, Mr. Chair. Thank you, Mr. Peterson, for your testimony. Appreciate it. Just trying to also kind of along these same lines about the movement of these contaminants. So upon the excavation of this partially buried vessel and the discovery of hydrocarbon stained soils and apparently ingress of groundwater, based on some of the photos where we see, you know, people inside of this excavation, and the surface is around about the height of their heads. So we're talking, you know, at least, let's say about 5 feet below ground or so. If the ingress, I mean, would you say in your view that the groundwater can vary at different levels below the surface? Like from the surface level below ground, that the point at which you can encounter groundwater will vary?
Yeah, you're asking me, does the groundwater table elevation change? Yeah,
Yes.
it fluctuates seasonally. It can be a few inches to a few feet, pretty
And
common.
especially if there had been a rain event, could that change that and increase it?
Especially in the alluvial aquifers, which is what we're talking about here. You know, unconsolidated materials with water in it, heavily influenced by storm events, and can fluctuate more widely.
Okay. And given that we saw some of the lab results where the exceedances of, you know, some of the contaminants were close to this tank battery, does that groundwater communicate with, how quickly would that groundwater, would that contamination move through the groundwater? You were talking more the movement through the soils. Can you speak to that?
So the contamination itself, we're talking about oil. It's not, you know, they say oil and water doesn't mix, but that's a little misnomer. It is slightly soluble. And so once that droplet of oil touches water, there's dissolution, there's solubility that occurs and dissolution into the water itself. And it happens instantaneously when that contaminant touches that water. And the speed at which the contaminants move in the subsurface very similar to the speed at which the water moves in the subsurface, because they are both liquids and moving through a similar homogeneous type of material. Does that answer what you're asking?
Yes, thank you. In your view, given the levels of contamination that were observed with some of the testing around the area, and actually, let me make sure, and Mr. Jacobs, please correct me if I'm misunderstanding, that those samples were taken as a result of the prior observed contamination. Is that correct, Mr. Jacobs?
Yes, the Apex report dated March 14.
Okay, yes.
Requested, Mr. Haddle was engaged specifically to do the investigation work that was identified as necessary in the very first Form 27 in November 2018 that was submitted to Mr. Axelson.
Yes. Okay, thank you. I that's what I had thought, but I just wanted to make sure before I ask the question. And perhaps this is a most appropriate question for Mr. Haddle, but given your qualifications as well, Mr. Peterson, it seems like you could potentially answer, but given the known contamination in the area and the results around that tank battery, would you say would it be a best practice to do some additional sampling around the tank before doing excavations that could potentially communicate with groundwater?
I grab samples when I'm trying to document something and to explain what site conditions are at any given point in time, would you grab those samples? And so if I was excavating around a sump that I was repairing and I encountered contamination that I believed to be pre-existing at the site, I probably would not be grabbing samples unless I was planning on disposing of that material in short order and didn't have any sample results to give to the landfill. But if you know that it's contaminated, there's not really a lot of purpose in sampling it other than to document that it is contaminated above the table 910 levels. And I think that was pretty well established already by the phase 2 report that Apex had prepared.
Okay, thank you.
Additional questions from commissioners? Seeing none, Mr. Jacobs, do you have any additional redirect post questions?
No, I do not, Mr. Chairman, but thank you for the opportunity.
Okay. In that case, I think we are ready for your next witness, if there is one.
Mr. Chairman, we do have some mini closing, Mr. Satterley, but I'm wondering if we're able to take our mid-afternoon break for just a short bathroom break and perhaps begin with our mini closing following that.
I think that's appropriate. Before we do that, let me ask if the commissioners have any witnesses on this particular NOAV that they wish to hear from. Commissioner Nanjapa?
I think at this point, if possible, I would just like to recall Mr. Canfield.
Thank you, Commissioner. Not hearing from my other commissioners. Ms. Rosenberg, if you will get Mr. Canfield queued up for after we return from the break, and we will hear from him then.
May I ask, is he going to be called before or after the mini closing? Sorry if that was stated and I missed it.
Let me confer with AG Davenport on that during our break, and I will let you guys know when we come back.
Thanks.
All right, then we will plan on returning about 3:18. Okay, it looks like we have all the commissioners back. Looks like we have council back. So what we'll go ahead and do is we'll go ahead and let KPK close out this NOAV, and then we'll ask for Mr. Canfield to come back for additional commissioner questions, and we will give both sets of council a very short opportunity for any additional questions that arise out of the commissioner's conversation with Mr. Canfield. Does that sound fair to everybody?
That's fine, Mr. Chairman, for the respondent, but may I please ask for a time check?
Sure. Pull that up for you now.
Yes. So, one moment. KPK's used 58 minutes and 48 seconds. Staff has used 1 hour, 5 minutes, and 45 seconds.
Thank you.
If you're ready, Mr. Jacobs, I think we are ready for you.
My colleague, Mr. Satterley, will do a mini closing for us. Lucas?
Thank you, Chairman Gonzalez. So first, as you've heard from Mr. Peterson and the other witnesses today, the contamination observed beneath the dislodged empty PPV was connected to historic contamination that KPK was already addressing at the location. Therefore, to the extent the commissioners enter a finding of violation for either Rule 905 or Rule 906, the commission should take into account that KPK was not the responsible party for the contamination when assessing any penalties. Second, to the extent there was a violation of Rule 905, which, as you know, KPK disputes, KPK maintains that several penalty reclassification principles should apply. At the outset, I want to clarify what I believe might be some confusion about what is being alleged in this NOAV in terms of degree of impact. For the Rule 905 violation, staff alleges that a major impact resulted from KPK's failure to submit a Form 27 prior to closure or removal of a produced water vessel. By contrast, for the Rule 906B violation, staff alleges that the failure to report a historic spill at this location via Form 19 resulted in a minor violation. Now, with that in mind, at most, the Rule 905 violation should have been classified as moderate, not major. Staff has not proved that the purported attempt to close the empty PBV prior to filing a Form 27 had any actual significant adverse impacts to human health or the environment, which, as we all know by now, is the standard for major violations. Like we heard for at least one NOAV last week and from staff's witnesses today, staff is yet again pointing to the proximity of the location to water bodies and streets in the area. And mere proximity is not sufficient evidence to show actual impact, much less an impact that can be classified as significant. Mere threats are not the threshold for the type of penalty staff is requesting here. And therefore, once again, staff has failed to meet its burden to show that a major violation has in fact occurred. Furthermore, KPK believes it would be appropriate to classify this Rule 905 as a minor violation because staff has not shown that the specific rule violation being alleged, which is closure of an empty PBV, had any actual adverse impact that is separate and distinct from that already being addressed by remediation of historic contamination at this location. And there was no additional threat of adverse impact that resulted from dislodgement of this empty PBV. And lastly, for reclassification, at the time staff required KPK to submit a Form 27 in September of 2019, KPK's efforts to clean up the historic contamination observed beneath the PBV had already commenced. Therefore, we believe this should be reclassified as a Class 1 violation for failure to submit a form at staff's direction. Now, in terms of penalty duration and pursuant to the penalty policy, no penalty should have been assessed for days where KPK was waiting for the staff to respond to KPK's September 10th, 2019 field inspection report resolution form, wherein KPK questioned the corrective action being required by staff. KPK did not receive a response from staff until October 2nd of 2019. This means that pursuant to the penalty policy, no penalties should have been assessed for the 23 days that KPK was waiting for this response and further clarification from staff. As for the Rule 906B violation duration, KPK maintains that penalties should not have continued to accrue for additional days beyond the reporting deadlines prescribed by Rule 906B. And adjusting penalties downward would be consistent with the Commission's policy that where a violation persists for a very long time, an extremely large penalty for minor violations can be disproportionate and unjust under the circumstances. Now, finally, as you also heard last week, remediation costs may be considered as a penalty adjustment factor. And to the extent the Commission finds any violations of Rule 905 or Rule 906, we believe this factor should receive due consideration in assessing any penalties. KPK has incurred significant costs in remediating historic contamination at the grant location. Contamination for which KPK is not the responsible party and which has provided no economic benefit of noncompliance to KPK. Thanks, and unless my colleague Mr. Jacobs has anything further, I believe that concludes our presentation of this NOAV.
Thank you, Mr. Satterling. I see Mr. Jacobs nodding in agreement, so I don't anticipate there's anything further from him. In that case, let's hear from Mr. Canfield, and I believe Commissioner Nanjapa has a question teed up for him.
Thank you, Mr. Chair, and thank you very much, Mr. Canfield, for reappearing to help me get some clarification. Just a couple of things to clarify my understanding of kind of the timeline of things. So upon your inspection on July 1st, you were not otherwise aware that there was anything happening with this vessel, correct?
Correct.
Okay. And upon your inspection, you saw that there was activity occurring and you went to talk to the personnel that were on site?
Also correct. We stopped them briefly so we could ask for clarification, ask about spill reporting procedures.
Okay. And upon just seeing that they were undertaking that activity, what sort of conversation did you have with them? I mean, like what sorts of things were you asking them?
So it was limited to identifying myself, asking them to stop, and asking two questions, asking if the work was taking place under an approved Form 27, or if there may be a proposed or requested amendment or modification to the existing 27, waiting for my review when I return to the office. Also asking about their spill reporting procedures. I realized the people I spoke with are not the ones who submit Form 19s, but I asked what their internal procedures were, who, if they make a discovery, what happens next? Who do they report to?
Okay, thank you. And on that specific point about discovery of a spill, did they acknowledge that there was evidence of contamination or staining?
Yes, they could see and smell what I saw and smell, but they also were very clear. They were certainly polite, courteous, but they told me that it was necessary for them to, especially in light of the work being stopped, to make the call to their, I'm not certain who, their supervisor, dispatcher. There were two calls. First person they contacted by phone could only redirect them to someone else.
Okay, thank you, Mr. Canfield. And that relates to my next question. So, so you did not directly speak, or they spoke to somebody first. That person did not know what the Form 27 was. So then they called somebody else, and then did you actually speak directly to that person, or were you communicating through them?
Both. With the second person, the KPK personnel held their phone out, and but it was a fractured conversation at best. I'm not clear who I was speaking to. They asked when the COGCC had begun requiring a Form 27 for removing a partially buried vessel. I wasn't trying to make light of the situation, but I told them that the requirement went back 20 years to 1998. Again, I can't be, I know I was not speaking to Max Knopp, and so it's not clear to me who
as far
that
as you
person,
know,
where they fit.
Okay, I'm sorry. Go ahead.
It's not clear to me where they fit in the reporting process, in the environmental management compliance process.
Okay, so as far as you know, it was not Max in that second call.
I'm absolutely certain I was not speaking with Max during that second call.
Okay, and so then when did you actually speak with Mr. Knopp? Was it that same day after you returned to the office, the next day? When was that?
I can't be sure if it was later that day or the next day, but
Say it was within a few days or within a week or approximately?
It would have been relatively soon to tell him that it would be necessary to amend the existing approved 27 to address the partially buried vessel, and separately to express that I thought I was looking at the discovery of a release point, a release mechanism. We were already, and I believe it's fair to say KPK as well, was already aware of at least two release mechanisms at the location. There's a flow line which had failed 3 consecutive integrity tests. There was piping in a manifold that we observed to be leaking and notified KPK.
Mr. Chairman.
Thank you.
I apologize, Commissioner, for the interruption, but I do have a concern about the scope of this response and the allegations at issue in this NOAV.
Thank you. Sorry, go ahead, Mr. Chair.
Yep. Mr. Jacobs, what's your specific concern?
My concern is that the witness is wandering into other matters not at issue in this NOAV. And I think it's inappropriate. We have certain rules alleged to be violated. We're putting on testimony and evidence relating to whether staff's met their burden as to the existence of those alleged violations. And while I respect the commissioner's right to ask questions and they get greater latitude, and I expect that that's always going to be the case, I am concerned, and you can say what you will, but I need to express that for the record at a minimum, and I've done that.
Thank you, Mr. Jacobs. Commissioner Nanjapa, do you have anything further along this line of questioning?
I do slightly, and I do concur somewhat with Mr. Jacobs in that there's just some specific timeframes I'm trying to establish here. So I want to know, when it was that you had spoken specifically to Mr. Noav as the Director of Environmental Compliance. It sounds like you are not aware of when that specific date was.
Yes, Commissioner, I'm uncertain of.
But relatively soon after the inspection occurred.
I believe it would have been relatively soon, yes.
Okay, and at the time of the inspection, you did not ask the personnel there whether they were removing or repairing or that nature of questioning? Yes.
No, my questions were simply whether or not there was an approved work plan and what the procedures were for reporting discovery of a historical release.
Okay, thank you, I appreciate that. And when you spoke to Mr. Noav, did you indicate to him that a Form 27 and a Form 19 were required?
Yes, I would have indicated that to comply with Rule 905, the Form 19 would need to be amended, not necessarily a separate second 19 submitted, but an amendment to the existing one.
Okay.
And also that I felt and still feel I was witnessing the discovery of a historical release mechanism that needed to be properly reported, properly documented.
Okay, thank you. Last question is, why was there a lag between the inspection and the submission of the report?
The reason is that COGCC staff enter their inspections on portable devices, on laptops, which are issued to them. And then the laptops are synchronized with our master record database. There was a problem with that synchronization that went undiscovered for, I believe, for 2 months and resulted in the lag of the inspection being added to the record.
Okay. And so the assertion that they did not know that a Form 19 was required until your submission, would you say that is correct or incorrect?
I'd have to say that was incorrect. There were different channels of communication, not just the exchange of forms and review comments and conditions of approval, but informal exchanges of email and telephone conversations.
And that telephone conversation that you said occurred within a few days at least of the inspection.
Exactly.
Okay, all right.
Yes.
Thank you so much, Mr. Canfield.
I see you, Commissioner Messner. Mr. Canfield, while we have you up here, I've got a question too that I'd
yes, sir.
Ask. What does notice to a surface owner look like?
So notice to the surface owner could take a variety of forms. I don't believe our rule specifies a specific channel of communication. It could be an email. It could be a phone call. For my part, I routinely suggest to operators that when they provide notice to a surface owner and or a local government, typically now as is done by email, that they copy me on the distribution list, and I reply in the affirmative to the entire distribution list that I am aware of this notice having happened, and I further urge the operators to preserve a copy of that email chain as a PDF and add it to the record for the spill or the remediation project.
Yeah, and that certainly sounds like good practice. But is it typical for an operator to notify a surface owner who is already on notice, given their knowledge of the potential release?
I don't know how to respond to typical. There's a lot of variation in this situation. The surface owner had engaged a consultant, and that consultant was frequently out there when I was out there, witnessing work being done by Mr. Haddle, conducting basically his own inspections on behalf of the surface owner. I believe they were being copied on submittals to the COGCC. And in the context of that communication, I would have expected some sort of notification, some communication to that person.
Sure. Just, I mean, given the situation as to the particular notice to the surface owner, I mean, it seems like it's been stipulated the surface owner was pretty well knowledgeable of what was going on location. Is that fair?
The surface owner was certainly knowledgeable. They had brought to our attention the discovery of contamination. What they would not have known would be the discovery of a potential release mechanism.
Sure, and that may very well be an important part of that notice. But in general, does the notice require updates, right? Once you notify a surface owner, hey, we found a spill here, is the operator required to keep them updated and keep them abreast of the developments of that spill?
Yes, sir. I don't have the rule in front of me to literally read it, but it does require ongoing communication and coordination in good faith between the operator and the surface owner.
Okay. Thank you, Mr. Canfield. I'm going to ask you, I think I have one last question, hopefully my last question, is in general, under 905B, the requirement to submit a Form 27 for the removal or for the closure of prior to the closure of a partially buried produced water vessel. What does that mean? What does the closure part mean? Like, when is a partially buried vessel closed to wit that would trigger the need for a Form 27 to go before that?
I believe it's closed once it is literally taken out of service. This particular vessel had been disconnected from the flow lines. The photos taken on the day of the inspection are pretty clear. It had been exposed, and at least what I was being told initially was the plan was to remove it. Now, I was told subsequently that would be for the purpose of some visual inspection, but
does that matter?
Does that matter?
Does it matter if the vessel is being removed for inspection and repair, or if it's being removed for another reason?
To me, it would not. If the vessel was going to be exposed, it presents an opportunity to make observations and collect samples for field screening and laboratory analysis that would be used to determine whether or not there has been a historical release. We already understood that, in fact, COGCC staff had witnessed at least part of the hydrostatic test that was mentioned earlier, which is a snapshot. We knew that there wasn't a current or real-time spill happening, but the hydrostatic test tells you nothing about the operational history of that vessel and whether or not could have been a historical release not previously discovered.
Okay. And given kind of the reportability requirements under 906B and the fact that there was groundwater contamination discovered, at least during the phase 2 analysis and investigation, would that not have triggered reportability at that point?
Yes, and definitely if someone happened during the course of their investigation, their response to discover a release mechanism or a likely release mechanism.
Okay. Thank you, Mr. Canfield. Commissioner Messner, I saw you had your hand up earlier and I interrupted you or I jumped the line, so it's your turn.
Thank you, Mr. Chair. I've got 2 questions. So the first question, and I believe you've already answered this, but I'm going to ask it anyway. KPK is indicating that the application of Rule 905B is a novel application. Do you believe that?
No, sir, I do not.
Okay, and why is that?
I believe it was standard practice on the part of the environmental staff, and I have 15 years of experience with the staff, including 8 years on the eastern side of the state, 7 years on the west side, to require an approved 27 prior to such work.
And my second question is, and Mr. Chair, while I acknowledge that there was a, Mr. Jacobs doesn't believe that this line of questioning may be appropriate, I do find the questions about the release mechanism to be relevant, because particularly in light of KPK indicating in their belief that this is a historic spill and are potentially looking at a reduction in penalties because it is a historic spill. And so I'm just trying to understand overall what's going on the ground by asking some questions about these found release mechanisms, because I guess I did not see that in any of the evidence that I had seen up to this point. So this is new information for me.
Our rules require that when the operator submits.
Pardon me, Mr. Canfield. I want to get a ruling from the chair to make sure it's an appropriate line of questioning.
Just to make sure I understand, Commissioner Messner, are you anticipating asking some questions as a result of kind of this ruling? Let me confer with AG Davenport on this. I have an idea, but I want to make sure that we're going down the right track. There we go. Found my mic. Commissioner Messner, I tend to agree with you that in regard to the to this being a mitigate or potential mitigating factor, and that idea being proffered by KPK as a potential mitigating factor for penalties, I think it's important to understand some details around that historical spill and what we know about it. So I'm comfortable with you moving forward with those questions.
Okay. Thank you, Mr. Chair. Mr. Canfield, you had initially talked a little bit about some potential existing release mechanisms that were found. I want to give you the opportunity to just explain those a little more, what they were, where they came from, and what potential impacts they could have overall on this site.
COGCC staff, myself and some of my colleagues, had observed leaks originating from a manifold. Separately, there was a flow line since removed that failed 3 consecutive integrity tests. So we would be looking at those 2 things as likely mechanisms, if you will, for releasing hydrocarbons into the subsurface. It is important to us, and indeed it's required by our rules, that the operator, in the form of a Form 19 supplemental report, provide us with a description of the root cause of failure, as well as measures the operator intends to take to implement to prevent a recurrence. That takes us back to why reporting the discovery of these release points or release mechanisms as they're found is important. It's the information we receive and our engineering integrity unit can evaluate concerning root cause of failure that ultimately leads to improved practices on the part of the operator, but also rules, policy, and guidance documents on the part of the agency.
Mr. Chair, if I may.
Mr. Jacobs?
We've not had an opportunity to respond to any of these allegations. We're hearing them for the first time from Mr. Canfield. I think this is prejudicial to my client's ability to get a fair hearing. And to the extent you're going to continue to allow this kind of answering second, third, fourth, fifth bite at the apple by Mr. Canfield, I need an opportunity to be able to respond, and I can't just turn on a dime and do it here and now. So I have to lodge my objection.
I appreciate your objection, Mr. Jacobs. I think you have an opportunity to address some of this in your close. Am I right about that? Okay. Yeah, you're gonna have a closing for kind of all three of these NOAVs, and so we'll look forward to hearing about that then. I understand that it is short notice, and this is a line of questioning that has come up as a result of us pulling back Mr. Canfield. And when we're done with our questions, I'm going to give Ms. Rosenberg a brief opportunity for redirect and give you a brief opportunity for cross to close this out. And so if that's fair, that's how I think we're going to proceed.
I appreciate your ruling. I respect your ruling. I still object, but I'll do with what I can with what I'm given. Thank you, sir.
Thank you, Mr. Jacobs. With that, Commissioner Messner, looks like you've wrapped up. Does anybody else have any additional questions, or do you, Commissioner Messner, have additional questions? Okay, with that, I'll give Ms. Rosenberg a few minutes, and then Mr. Jacobs, I'll give you a few minutes.
We have no questions. Thank you.
Mr. Jacobs?
You referred to some pressure testing of a header at this location that had failed several pressure tests. This is all very recent vintage activity, is it not, Mr. Canfield?
Sir, I was referring to leaks we observed at the header. It is the flow line that failed the integrity tests.
Yes, but these are all recent tests that you're talking about, and I've not had the opportunity to investigate in preparing my defense. Is that correct?
So these are observations and integrity testing done during the first and second quarters of 2019. I don't know if that fits the bill for recent.
It is fairly recent relative to the historic contamination about which Mr. John Peterson testified earlier. That is my only point. The only point I'm able to make, given the expansion of the scope. Again, I renew my objection as to relevance, and I have no further questions for this witness at this time, but I will address his testimony in my closing as suggested by the chairman. Thank you.
Thank you, Mr. Jacobs, and thank you, Mr. Canfield, for coming back and testifying, giving us more information. With that, I think you can be dismissed. We've heard the staff's case in chief, KPK's case in chief, and it looks like we are all done with the NOAV associated with the Grant tank battery. Given that it's 3:50 in the afternoon, I think that it would be challenging to begin to endeavor into the Charter Schneider tank battery NOAV. Therefore, it's my suggestion that we take that up first thing Friday morning after we have an opportunity to take action on the motion from staff on the withdrawal for the Wagner #1. I see Ms. Stafford has popped up. Do you have anything to share with us?
I would like to make a suggestion of my own if this could work. We will actually not have one of our witnesses this Friday. We were anticipating he'd be able to testify today. So if I could introduce the Charter Schneider NOAV and put on Mr. Axelson is our first witness. It will be a very brief direct, potentially a brief cross. It's a very streamlined line of questioning.
Mr. Jacobs, any objections to that? I mean, we'll hear from Mr. Axelson, but that would be it.
Mueller's lead on Charter Schneider. Kirk?
Mr. Mueller?
Accepting what Ms. Stafford has said is true, that this is going to be a small part of their case in a short testimony. There'll be a little bit of a disconnect starting with Mr. Axelson, then a day of nothing, and then take it up again on Friday. That notwithstanding, I'm okay with proceeding.
Yeah, I understand that it's a little bit clunky, but we got to do what we got to do. And I think that we are limited on time today, given that we've got our 6 p.m. public comment hearing. So let's go ahead and get started with Mr. Axelson. We'll get through Mr. Axelson's testimony, full cross commissioner questions, the whole suite, and then we will end for today. So with that, Ms. Stafford, if Mr. Axelson is ready, let's get him as a panelist and get going.
Sure, and just a quick clarification, do you want me to do my sort of brief introduction to the location first, or should I hold that for Friday?
Okay, yeah, I think AG Davenport makes a good point there in that we need some basis to go from. So why don't you go ahead and set the stage for us, and then we'll hear from Mr. Axelson. Before you start, Commissioner Messner, I saw your hand up. Do you have anything to add?
Sorry, no, Mr. Chair. I was going to suggest that I needed some context, so the opening would be good. So thanks for that.
Fair enough, and we'll do our best to get through it and give all the parties due time. So let's get started.
Thank you so much. Good afternoon, Commissioners. AAG Caitlin Stafford on behalf of Commission staff. In this NOAV, you will learn about the Charter Schneider tank battery location. As I described earlier today, this location has had 3 separate remediations occurring as a result of 3 separate spills and multiple corrective actions that went unaddressed for months. Commissioners, there are already agreed upon facts in the parties' joint stipulated facts that get staff close to proving these violations. The parties agree that following an August 22nd, 2019 inspection, KPK was provided with corrective actions to post a sign at the location, install adequate safety fencing, install stormwater BMPs, and provide required additional environmental documentation. The parties also agree that following a September 24th, 2019 engineering inspection, KPK was required to comply with Rule 603F, mark risers and seal flow line ends, remove unused flow lines, and properly abandon flow lines in accordance with Rule 1105B. And as the stipulated facts, as well as staff's evidence and testimony will show, KPK did not meet any of these corrective action deadlines. And now I would like to call staff's first witness, Mr. John Axelson.
Hello, can you hear me?
We hear you, Mr. Axelson, but we do not see you. And there we go. We see you, and I think you're ready.
Thank you.
Thank you for joining us, Mr. Axelson. I believe we heard from you briefly last week, but if you could please remind the commissioners who you are and your title here at COGCC.
Yes, this is John Axelson. I'm the East Environmental Supervisor for COGCC, working the east half of the state with a group of 8 environmental protection specialists.
And Mr. Axelson, I would like to take the opportunity to talk to you a little bit about the Charter Schneider NOAV generally. Now, are you aware of the allegations contained in this NOAV?
Yes, I'm aware. My staff members brought the violations forward, and I was aware of those violations that were alleged.
And one particular violation alleged deals with prior Rule 901C. Can you speak a little bit about the documentation staff was asking for under Rule 901C?
Yes, we were asking for updates on the planned remediation project. I think corrective actions were set when we weren't getting updates and seeing progress. So under 901C, we set some dates for supplemental Form 27s so that we'd be able to really get KPK back on the clock with an implementation schedule so that we knew they had a plan to proceed timely to clean up the impacts at this location.
And you mentioned the multiple remediations here. Those are 9522, the project numbers, excuse me, 9522, 12787, and 13053. Can you just generally explain your understanding of those particular projects?
Yeah, I mean, they had multiple spills and releases at this location. Each one had a separate spill release point that they were required to clean up.
Okay, and based on your experience at this agency, is it typical for a location to have 3 simultaneous remediations going on?
No.
Now, do you recall any issues or problems with these particular remediations?
Again, just the timeliness of the corrective actions being made. There were many issues going on, failure to have BMPs around contaminated soil piles, fencing around open excavations, some of the similar things that we've heard on other locations. I believe there was rule violation for signage. So yeah, there were a lot of issues related to the way they were progressing with remediations.
And previously, you've spoken about Forms 27 and the work plans that are required prior to beginning a remediation project. In the time period mentioned in this particular NOAV, did COGCC have accurate work plan information for these projects?
No, we did not.
And why is that, to your best understanding?
We weren't getting updates on the projects. And so we go out, inspect, ask for corrective actions to provide a supplemental report. So again, like I said, so we know what their schedule was going to be and to make sure that impacts weren't continuing to migrate, that the open excavation wasn't continuing to provide a risk to the public or wildlife. We just didn't have an understanding of what was taking place.
And excuse me, I'll back up a second. So why does the COGCC need accurate Forms 27 for multiple remediation projects?
We want to be sure that first their approach on additional remedial investigation and or the actual remediation itself is something that we agree to, that it's appropriate for the impacts. We want to make sure that the documents that are in the record are available for anybody. Local governments look at these records, other regulatory agencies, surface owners, other staff that might not be working on environmental work, but they might need to know what was happening at a site. So the record needs to be kept up to date, and it's a public record.
And when these forms aren't accurate or you don't have up-to-date forms, are there any impacts or threatened environmental impacts that are associated with that?
Certainly there's ongoing threat to the environment, and we can't gauge whether those impacts have been mitigated. So yeah, if there's surrounding sensitive receptors such as domestic water wells or surface water or critical wildlife habitat, we don't know if the impacts have been taken care of and if those sensitive receptors are still at risk.
Thank you, Mr. Axelson. I don't have any further direct questions for this witness.
Mr. Mueller?
Thank you, Mr. Chairman. Mr. Axelson, have you been to the Charter Schneider tank battery site?
No, sir, I have not.
The fact that there were 3 simultaneous remediations going on, that in and of itself is not a violation. It's just a situation that you and we were contending with, isn't that correct?
That's correct.
No part of the NOAV is based on the fact that there were 3 simultaneous cleanups.
Correct.
The simultaneous cleanups did create a confusing situation, and we're going to hear more about it, I guess, when we hear more witnesses. Would you agree that to some extent staff was confused by the 3 projects as well?
Yes, we were trying to keep track of those projects.
You don't know of any actual impacts to the environment based on migrating contamination from the site, do you, Mr. Axelson?
No.
I don't have any further questions.
Redirect, Ms. Stafford.
Thank you, Mr. Chair. Just a few brief questions for Mr. Axelson. Mr. Axelson, council just asked you if you had ever been out to the Charter Schneider location. Have you had the ability to review inspection reports, photographs, other documentary evidence of at this particular location?
Yes, I have.
So you would say you're generally familiar with what is going on at this location?
Yes.
Okay. Thank you. I don't have anything further.
Okay.
Questions from my fellow commissioners? I'm not seeing any, so I think that wraps up Mr. Axelson's testimony.
All right. Thank you all.
You bet.
Thank you.
Okay, then we will close up for today and prepare for Friday morning. We will have we'll have any unnecessary discussion and ruling on staff's motion to withdraw Wagner number 1. Then we will continue the Charter Schneider tank battery and, if necessary, the Wagner number 1. If at all possible, if we can get through all the way through party closings on Friday, that would be ideal for us commissioners to have the weekend to deliberate and come in ready Monday to pursue those deliberations and move forward.
Mr. Chairman, before we say goodbye, and not meaning to press staff, I'm wondering if we have a sense of when they might get their brief on the motion to the commission, and then maybe when the commission might be in a position to rule. We have to decide whether we're going to have witnesses standing by for Wagner come Friday. And I know we're all stuck with the situation, but if there's an update from either the commission or from staff, I'd welcome that myself.
Well, I'll ask for an update from staff here in a second, but given that we haven't given notice for this particular hearing to the public for us being meeting tomorrow, I don't know if we could even get together. So it may have to push to Friday morning at the earliest anyways. And I apologize for any inconvenience to your witnesses. I understand what, they may be in limbo. But I will turn to staff and see what the timing is on their motion, just so that we understand what that looks like.
I think we had discussed earlier today, we would do our best to get it to you as soon as possible, and we will file tomorrow morning.
Okay. So we'll get that tomorrow morning. We'll all take a look at it. We'll be prepared. If we have any questions for our attorney on our end, I think that we will engage on that individually, and hopefully be prepared to discuss that first thing Friday morning. So at the very least, if your witnesses are holding on to that date, that they will know as soon as we can let them know whether or not they will be required to testify on Friday.
Thank you, Mr. Chairman.
Sure. So with that, I know that we have public comment at 6. Is that a continuation of this particular hearing, in which case we do not adjourn, or we do not?
Yeah, we should just adjourn until 6 o'clock.
Okay, we're just going to go ahead and look for a motion to adjourn until 6 p.m. tonight.
Mr. Chairman, if I may I trouble the hearings manager for another time check briefly?
Glad to tell you that, Mr. Jacobs.
Thank you so much.
Yes, Mr. Jacobs, KPK has 1 hour and 28 minutes and 55 seconds remaining. Staff has 2 hours, 21 minutes, and 56 seconds remaining. And I was just about to hit send on an email to you all with the numbers, so.
Thank you so much.
Thank you.
All right, there we go. So I'm looking for a motion to adjourn to 6 p.m. this evening.
So moved.
Second.
All those in favor? Aye.
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 Then we will see you guys back, my fellow commissioners, at 6 p.m. We've got a handful of public commenters we look forward to hearing from, and we will see everyone back then. Thank y'all.